Yes, attorney.
Okay. Last meeting, I believe we discussed the grounds for the declaration of nullity of marriage, as well as the grounds for annulment of marriage, pati ang grounds for legal separation. And I'm sure that you guys are already familiar with the distinction between declaration of nullity of marriage, annulment, as well as legal separation. When we talk about the effects of the annulment of marriage as well as the declaration of nullity of marriage as compared to the decree of legal separation. Kung legal separation, guys, kay baumantan na it will not sever the marriage bonds between the parties, okay? Ma-separate lang sila between bed and board. But with respect to the marriage bonds, it's still intact. Minyo gihapon sila. Meaning, dili pwedeng magnuyab si bana or si asawa, otherwise they will be prosecuted for either bigamy or adultery as the case may be. Now, with respect to the effect of declaration of nullity of marriage as well as annulment, kani sila, this will dissolve the marriage ties between the parties. All right? The moment there's a decree of nullity of marriage as well as annulment, wala na'y marriage between the husband and the wife. Meaning, free na si husband and wife to remarry. Okay? Mao na siya ang basically effect sa decree of nullity as well as annulment of marriage as opposed to the decree of legal separation. Now, we already talked about the grounds as well as the effect. We will now go to the property relations between the husband and the wife. Article 74, ladies and gentlemen, talks about the property relationship between the husband and the wife. According to Article 74, ningon siya diri guys, nga the property relationship between the husband and wife shall be governed in the following order. In the following order, meaning, unahon natong tan-aw, kung naabay marriage settlements executed before the marriage, kani bang gitawag nato sa atong layman's term nga prenup agreement, prenuptial agreement. Kung naa na guys, diha nimo tan-awon kung unsay property relations between the parties. Like Bekebelo og ni Hayden ko, kana sila. Before they entered into the contract of marriage, they executed a marriage settlement governing the property relations between them. So tan-aw na nimo, if there's a marriage settlement will govern the property relations between the parties. Kung walay marriage settlements, musod ang provisions of the family code. Unsa man ang naa sa provision sa family code na ay tulo ka property regime nga gi-mention ang family code. Una, ang absolute community of property. Ikaduha, ang conjugal partnership of gains. Ang ikatulo, ang gitawag nato nga complete separation of property. Okay? Timan guys, when we talk about marriage settlement, this is actually the contract entered into by the future spouses. Fixing ni guys. Fixing the matrimonial property regime that should govern during the existence of the marriage. Okay? Bali, kontrata nilang duha kung unsay property relations nga mo govern during sa kaminyoon. Is it mixed ba? Pwedeng i-combine nila ang complete separation as well as conjugal depending on what is fixed in the marriage settlement, or pwedeng a complete separation of property, pwedeng a conjugal partnership of gains. Okay? In the absence of a marriage settlement, ang mo-govern, as I mentioned earlier, are the provisions of the family code. Ang giingon sa family code, kung walay marriage settlement, the future spouses may, in the marriage settlements, agree upon the regime of absolute community. Pwede sila magsabot, either absolute community. Ikaduha, pwede conjugal partnership of gains, or complete separation of property, or any other regime. And in the absence, kung wala sila'y gikasabutan nga marriage settlement, or when the regime agreed upon is void, ang mo-govern nga property relations between the parties is the system of absolute community of property. Okay? Balik ko na ko. Kung naay marriage settlement, whatever is stated in the marriage settlement, maunay mo govern nga property relation between the parties. In the absence of any marriage settlement, ang general rule ana, ang governing property regime between the husband and the wife is the system of absolute community of property. Okay? System of absolute community of property. Ato nang minugbuon, that is actually ACP, absolute community of property. Kumain kag conjugal partnership of gain, CPG. Okay? Para dali ra ninyong ma-remember. Ang complete separation of property is CSP. Butangin lang na ninyong mga abbreviation dira or acronyms, whatever you like, para dali ra ninyong mahinamduman, guys. Okay? Now, Article 76 would provide that in order that any modification in the marriage settlement may be valid, it must be made before the celebration of the marriage. Of course, subject to the provisions of Articles 66, 67, 128, 135, and 136, which we will discuss later on. 66 and 67, we discussed that earlier. So kung mag-modify ka with respect to the provisions of the marriage settlements, kailangan inyo nang buhaton prior sa celebration sa marriage. Okay? Kung wala gani na siya nga modification, kung unsa man to inyong naagrihan originally sa marriage settlements, will govern your marriage. Okay? Now, Article 77, the marriage settlements and any modification thereof shall be in writing. It has to be signed by the parties and executed before the celebration of the marriage. They shall not prejudice third persons unless they are registered in the local civil registry where the marriage contract is recorded, as well as in the proper registries of properties. Kung ugaling makadecide si Glenda o ang iyang future husband nga mo enter into a contract of marriage and before the celebration of marriage mo entrada sila og marriage settlement, before na makabind sa third persons, before na ma-invoke later on during your separation, kailangan na siya nga i-register with the proper local civil registry, okay? And at tusad sa proper registries of property. If it concerns properties, imo po nang ipa-annotate dito kung asa na-locate ang imuhang property, okay? When we talk about local civil registry, kung asa nahitabo ang kaminyoon dito na or asa mahitabo ang kaminyoon ato na i-register unya ang inyuhang marriage settlement. Okay? So it has to be registered before it can bind third persons. Now, Article 78 and 79, matters of reading, Article 80, kaning Article 80. Article 80 provides that in the absence of a contrary stipulation in the marriage settlements, the property relations of the spouses shall be governed by Philippine laws, regardless of the place of the celebration of marriage and their residence. Okay? When it comes to the marriage settlement, national law sa parties ang mo govern. Okay? So, Philippine laws. But this rule shall not apply, ladies and gentlemen, kung both spouses are aliens, naturally. Okay? With respect to the extrinsic validity of contracts affecting property not situated in the Philippines and executed in the country where the property is located. So if the agreement does not concern any property in the Philippines and it was entered into outside of the country, okay ra nga di sila mo follow diri sa ato ang gi-require nga extrinsic validity in order for the contracts to be considered valid. Diri sa ato ang test sa validity extrinsically sa contract is katumang it has to be in writing, di ba? It has to be registered with the proper local civil registry as well as the registries of property. Naturally, kung wala diri ang property sa atua o kung wala diri gi-execute, they are not bound to follow the requirements provided for by our laws. Number 3 is with respect to the extrinsic validity of contracts entered into in the Philippines but affecting property situated in foreign country whose laws require different formalities for its extrinsic validity. Okay? Same gihapon, but ang property here is located outside of the country, although the contract is being entered into here in the Philippines. Now, Article 81 provides that everything stipulated in the settlements or contracts referred to in the preceding articles in consideration of a future marriage, including donations between the prospective spouses made therein, shall be rendered void if the marriage does not take place. Okay? However, stipulations that do not depend upon the celebration of marriage shall be valid. So whatever agreement entered into in the settlements or whatever donations made in consideration of marriage, mahitabo ng void tanan if the marriage does not take place. Okay? Pero kung ang stipulation does not depend upon the celebration of the marriage, let's say for example, also in the marriage settlement or in the donation, maybe, gi-acknowledge dito, let's say ni Joseph, gi-acknowledge ni Joseph in the donation ang iyahang anak in that instrument. Even if there is no celebration of marriage, even if dili madayon ang kaminyoon, the acknowledgement of the child will remain valid. It will not be affected by the nullity of the donation just because the marriage did not take place, because it does not depend upon the celebration of the marriage. Okay, mo ni mga instances wherein ang stipulation does not depend upon the celebration of the marriage. I hope klaro na siya. Kani donation by reason of marriage. Okay? Unsa maning donation by reason of marriage? Donations by reason of marriage are those which are made before its celebration in consideration of the same and in favor of one or both of the future spouses. These donations are governed by the rules on ordinary donation established by Title 3 of Book 3 of the Civil Code insofar as they are not modified by the following articles. Kani, Article 84, take note of this. If the future spouses agree upon a regime other than the absolute community of property, they cannot donate to each other in their marriage settlements more than 1/5 of their present property. Any excess shall be considered void, and donations of future property shall be governed by the provisions on testamentary succession and the formalities of the will. Kani ko no, let's try to answer this. Pwede din akong mag-credit sa inyong recitation. Kisa may ganahan mo answer ani. Example, si Glenda, makigminyo siya ni, mangita tag kalab team din ni Glenda, bikajuta. Let's say si Carlo, okay? Glenda and Carlo decide to get married, and in their marriage settlements, they provided, or si Glenda nag-provided to og donation, let's say billionaire si Glenda, and Glenda would want to donate 1/2 of her property nga to kang Carlo, kay gugma kay sang Carlo ana sa Carlo, I hereby give 1/2 of my entire net worth to you as a sign of my love and devotion and loyalty and in consideration of our future marriage. Okay? Can that donation made in the marriage settlement be considered valid? Again, Article 84. Niingon ng Article 84, if the future spouses ko no agree upon a regime other than the absolute community of property, they cannot donate to each other in their marriage settlements more than 1/5 of their present property. Pasabot kung ang inyuhang giagrihan na property regime is either conjugal partnership of gains or complete separation of property, you cannot donate to each other more than 1/5 of your present property. Okay? Pero kung ang inyuhang property regime is that of the system of absolute community of property, bisag pila pa na imong i-donate diha Glenda, it doesn't matter. Okay? It will not be rendered void. Because ang concept sa absolute community of property, if you have been reading in advance, kung unsay imuha Glenda before sa kaminyoon, ug unsay kang Carlo before sa kaminyoon, inigsod ninyo sa marriage, mainyuhan naman na duha in common. Okay? Mao nang absolute community of property. When we talk about conjugal partnership of gains, whatever is yours before the marriage, whatever is Carlos before the marriage, remains yours and his. Okay? So kung unsay imong property before sa kaminyoon imuha na, kung unsay kang Carlo before sa kaminyoon ihasad na. Ang mainyuha ra ana nga conjugal partnership is whatever is acquired during the marriage as well as the profits of your katong property ninyo prior sa kaminyoon. Kakuha mo guys? So kung absolute community of property ang property regime, walay prohibition as to pila ang imong ihatag nga donation by reason of marriage. But kung ari kas conjugal or complete separation of property, kailangan up to 1/5 lang. Beyond that, it shall be considered void. Okay? Ang mavalid ra is only up to 1/5 of the present property. Dayon, donations of future property shall be governed by the provisions of testamentary succession and the formalities of the will, which of course you will learn later on in your study of the law as you progress no in your next levels. Nakuha ra mo ani guys katong first paragraph, Carlo?
Yes, attorney.
Okay. Okay, donations, Article 85, donations by reason of marriage of property subject to encumbrances shall be valid. And in case of foreclosure of the encumbrance and the property is sold for less than the total amount of the obligation secured, the donee shall not be liable for the deficiency. If the property is sold for more than the total amount of the said obligation, the donee shall be entitled to the excess. You, Sir Bon, may decide to give a donation to spouses Carlo and Glenda. Okay, example, ganahan ka mohatag og sakyanan ni Carlo og ni Glenda by reason of their marriage, Sir Bon, but the said car, let's say ang Mercedes, naka-mortgage sa bangko. Okay, there is an encumbrance over the car. And then, pag nakalimot kag bayad, Sir Bon, kay busy kay kastanan, sige kag tuon na nakalimot na ka nga na di kay beranan, so na-foreclose ang sakyanan. Now, during the foreclosure, if there is a deficiency in the amount of the proceeds of the sale, meaning kay kung i-foreclose go na, di ba, auction man na, ingana, so kung kinsay highest bidder, mo man ay makakuha. So let's say kung ang bid is lesser than the obligation over that particular car or over the mortgage of that particular car, dili liable si spouses Glenda and Carlo. Okay? Mora na ipasabot ani. But if the property is sold more than the total amount of your obligation, ang donee will be liable to the excess. Okay? So win-win ra siya, Sir Bon. Pareha ra sa imong giyon ganiha. Only the difference here is that ang third party mo ining donate sa spouses. Okay? But it could also be wherein ang other spouse would like to donate to the future spouse. The same is true. Ang rule is kung nanay encumbrance ka na nga certain property, ang gihatagan kay donation good na, di siya liable for whatever deficiency nga mo arise from the obligation during the sale or foreclosure. Okay? Kuha naman, guys? Pero with respect to the excess, entitled siya for the excess. Okay? Klaro ra ba?
Yes, attorney.
Yes, attorney.
Klaro ra, attorney.
Okay. Thank you. Now on to Article 86. A donation by reason of marriage may be revoked by the donor in the following cases. If the marriage is not celebrated or judicially declared void ab initio, except donations made in the marriage settlements katubitang not dependent on the celebration of the marriage. Then number 2, when the marriage takes place without the consent of the parents or guardians as required by law, when the marriage is annulled and the donee acted in bad faith upon legal separation and the donee being the guilty spouse, and if it is with resolutory condition and the condition is not complied with, and when the donee has committed an act of ingratitude as specified by the provisions of the Civil Code. Basically, kaning mga conditions, you actually found this in the effects of annulment of marriage and declaration of nullity of marriage previously discussed nato in the past. Okay, so mo lang ni siya, if donation by reason of marriage, pwede na siyang ma-revoke sa donor in any of these cases under Article 86. And I hope you get to familiarize the grounds for the revocation of the said donation. Now, kaning 87, mao ni siya basically ang murag kusog-kusog sa kaning provision or chapter on donation by reason of marriage kaning Article 87. Niingon ang Article 87 nga every donation or grant of gratuitous advantage, direct or indirect, between the spouses during the marriage shall be void. Okay? So, kung mag-donate tayo mo kanang mutual donations ba between the parties or between the spouses during the marriage, it will be considered void. Except, of course, for moderate gifts which the spouses may give each other on the occasion of any family rejoicing. Kani ko no, Carlo and Glenda, example, during sa inyong marriage, nihatag si Carlo og diamond earrings worth, let's say, 2 million. Will that be considered a valid gift? Will that be considered a moderate gift? Kaya technically, when you give something, that's actually an act of donation, di ba? You give something out of pure liberality. Mo na ang definition sa donation. So karon, if you give your spouse, Glenda, Carlo, an earring, okay, or a pair of earrings worth 2 million pesos, will that be considered a moderate gift? Kay, let's say, si Carlo is as rich as, let's say, Lucio Tan. Oh, di ba? So, ang iyahang 2 million, sincero na. So, kung muhatag ka og diamond earring at kang Glenda, it's just a moderate gift. Pero kung, let's say, si Carlo is still in law school, in Gulyas Law School, and depending on his parents for his education, niya, si Glenda ang naray trabaho niya, muhatag siya karon og 2 million worth of earrings. Di na siya moderate na gift. So, it basically depends on the income or the resources of the parties. Okay? So, timan ilang, when you make donations, generally it's void, but kung moderate gifts lang na kanang mga anniversaries, mga anniversary gift ninyo, monthly gift, o diba na monthly gift, it will be considered moderate depending on your income or your financial capacity. But remember this last sentence, mo niyang na-issue. The prohibition shall also apply to persons living as husband and wife without a valid marriage. Okay? In the case of Matabuena versus Cervantes, giklaro ni sa Supreme Court nga the prohibition against donation between spouses during the marriage is also applicable to common law relationships. Okay? Dili lang ni siya between spouses wherein there is a subsisting marriage, but also to common law relationships. Kanang ipon-ipon. Gibawal manggani ang minyo samot na ang ipon-ipon. Okay? Ang rationale sa balaod mo ni, niingon si JBL, Justice JBL Reyes, if the policy of the law is to prohibit donations in favor of the other consort and his descendants because of fear of undue and improper pressure and influence upon the donor, a prejudice deeply rooted in our ancient law, then there's also every reason to apply the same prohibitive policy to persons living together as husband and wife without benefit of nuptials. Okay, timan ilang ninyo, ng Article 75 is also applicable to persons living together as husband and wife. Meaning, bawal gihapon, bisan pag common law lang ang ilang relationship, ang donation during the cohabitation. Okay? I hope klaro na siya, guys. So, as mentioned earlier, there are actually 3 property regimes mentioned in the family code. Mauni ang system of absolute community of property, ikaduha ang conjugal partnership of gains, ang ikatulo ang complete separation of property. Now, you may ask, unsa maning absolute community of property? Ako naman gi-explain ganiha atong tinambanon kung may kag absolute community of property, ano to? Nalagi uris-uris ni. Okay. Kung may tag absolute community of property, tanang property ni Glenda o ni Carlo before sa ilang kaminyoon will be theirs during the kaminyoon. So, kung naay 10 million si Glenda, 1 million si Carlo before the marriage, when they get married, kanang 1 million og 10 million magtipon na nga ilahang duha. Common na nila nga property, okay? Maora na ang absolute community of property. And also the properties that they may acquire during the subsistence of the marriage, okay? Now, when we talk about conjugal partnership of gains, simply put, ang pasabot raani, kang Glenda na siya 10 million before the marriage, si Carlo na siya 1 million before the marriage, kana will remain to be Glenda's 10 million even during the marriage. Also si Carlo naa siya 1 million even during the marriage. Pero kung nanas bangko niya magka-interest na, whatever interest nga mag-gain anang 10 million o 1 million ni Carlo will form part of the conjugal partnership of gains. Unsa pa may laing mosud sa conjugal partnership of gains? All properties, all income nga ma-obtain nila during sa ilang kaminyoon, okay? Pero before sa ilang kaminyoon, ilaha tong tagsa-tagsa ka mga separate property. Now, when we talk about complete separation of property, kaning complete separation of property, iya ba? Murag subol pa, ija-ija, aho-aho ba? Kung unsa ray property ng Glenda before and during the marriage, iyahara na. Kang Carlo before and during the marriage, iyahara sad na. Magsabot ra na sila with respect to the common expenses sa ilang panimalay. Okay? Mauna ang complete separation of property. Now, para mo tuo mo nga mao na ang absolute community property niingon ang 88 nga the absolute community of property between spouses shall commence at the precise moment that the marriage is celebrated. Any stipulation either expressed or implied for the commencement of the community regime at any other time shall be void. And then no waiver of rights, shares, and effects of the absolute community of property during the marriage shall be made or can be made except in case of judicial separation of property. When the waiver takes place upon a judicial separation of property or after the marriage has been dissolved or annulled, the same shall appear in a public instrument and shall be recorded in or as provided for in Article 77 katong gisgutan ganiha sa Paper Civil Registry o sa Registry of Properties. And then the creditors of the spouse who made such waiver may petition the court to rescind the waiver to the extent of the amount sufficient to cover the amount of their credits. Because later on, sa ato ang discussion, makabaw mo nga, bisan pa og absolute community of property ang nasabutan during the marriage or conjugal partnership of gains, it can be that there be a judicial separation of property during nasa kaminyoon, which we will discuss further later on. And kaning provision sa co-ownership shall apply to absolute community of property between spouses in all matters not provided for in this chapter. Pasabot ra ana nga mo lagi to akong giing ganiha tanan nimong dadon sa kaminyoon o tanan ninyong ma-obtain during sa kaminyoon mura nag inyong gi-co-owned duha. Conceptually, it's co-owned by the spouses, the husband and the wife. Now, what constitutes community of property? Unless otherwise provided in this chapter or in the marriage settlements, the community property shall consist of all the property owned by the spouses at the time of the celebration of marriage or acquired thereafter. Okay? Tanan nimo nga property owned during the celebration of the marriage o katong imong ma-acquire after sa celebration sa marriage. But there are properties which are considered to be excluded from the community property. Okay? Unsa man ni nga mga properties ang excluded? Una, property acquired during the marriage by gratuitous title by either spouse and the fruits as well as the income thereof, if any, unless it is expressly provided by the donor, the testator, or grantor that they shall form part of the community property. Unsa may pasabot ani? Si Glenda baron gitagaan siya o nakamana siya before sa kaminyoon og let's say 1 billion pesos from her parents. Kanang iyahang 1 billion nga na-acquire mo may pasabot sa gratuitous title kanang iya bang nadawat nga way kapalit bitaw. It's because of gratuitous title. So, kung iya nang namana na-inherit, it could either be inheritance or donation man. So, kung iya nang na-inherit, it will not form part of the absolute community of property. Except kung sa will baron, kung iya tong na-inherit, or sa deed of donation bayron, kung gidonate na sa iya gi-provided to nga kani siya mo form part sa community of property. Otherwise, the general rule is, kanang nga property acquired by Glenda during the marriage by gratuitous title is considered to be her separate property. Okay? Ikaduha, kaning property for personal and exclusive use of either spouses. Okay? Unsay may mga gamit nimo nga personal and exclusive use to you, that's yours. That's your exclusive property. Pero kaning jewelry, it shall form part of the community property. Okay? Now, also, property acquired before the marriage by either spouse who has legitimate descendants by a former marriage, and the fruits as well as the income, if any, of such property. Kung kaduhan na day naminyo si Glenda, kung nana siya property during sa iyang first marriage, kato will remain to be her separate property. Okay? Kaya nga naman, subject to siya to the legitimate children sa iyang previous marriage. Now, property acquired during the marriage is presumed to belong to the community unless it is proved that it is one of those excluded therefrom. Generally, kung unsa may property nga ma-acquire ninyo, ang presumption ana na it belongs to the community of property. Now on to the charges and obligations of the absolute community. May I ask Glenda to please read Article 94.
Article 94, the absolute community of property shall be liable for, number one, the support of the spouses, their common children, and legitimate children of either spouse. However, the support of illegitimate children shall be governed by the provisions of this code and support. Second, all debts and obligations contracted during the marriage by the designated administrator spouse for the benefit of the community or by both spouses or by one spouse with the consent of the other. Number three, the debts and obligations contracted by either spouse without the consent of the other to the extent that the family may have been benefited. Fourth, all taxes, liens, charges, and expenses, including major or minor repairs upon the community property. Fifth, all taxes and expenses for mere preservation made during marriage upon the separate property of either spouse used by the family. Sixth, expenses to enable either spouse to commence or complete a professional or vocational course or other activity for self-improvement. Seventh, antenuptial debts of either spouse insofar as they have redounded to the benefit of the family. 8. The value of what is donated or promised by both spouses in favor of their common legitimate children for the exclusive purpose of commencing or completing a professional or vocational course or other activity for self-improvement. 9. Antenuptial debt of either spouse other than those of falling under paragraph 7 of this article, the support of illegitimate children of either spouse and liabilities incurred by either spouse by reason of a crime or quasi-delict in case of absence or insufficiency of exclusive property of the debtor's spouse, the payment of which shall be considered as advances to be deducted from the share of the debtor spouse upon liquidation of the community. And lastly, expenses of litigation between the spouses unless the suit is found to be groundless. If the community property is insufficient to cover the foregoing liabilities, except those falling under paragraph 9, the spouses shall be solidarily liable for the unpaid balance with their separate properties.
Okay. Thank you, Glenda. Basically, these are the expenses that the absolute community of property may be held liable. Ako lang i-discuss ani is kaning paragraph 3, kaning debts and obligations contracted by either spouse without the consent of the other to the extent that the family may have been benefited. This was discussed by the Supreme Court in the case of Ayala Investments versus Court of Appeals. What actually happened in this case, kay kaning si si Cheng is actually an employee of the Philippine Blooming Mills or PBM. So si PBM obtained 50.3 million loan from Ayala Investments. Si respondent Cheng here is actually or was the EVP, the Executive Vice President of the Philippine Blooming Mills. He executed a security agreement on December 1980 and March 1981, making himself jointly and severally answerable with PBM's indebtedness to the Ayala investments. Pero ang PBM actually failed to pay the loan. Hence, they filed a complaint against PBM and Ching. So, gi-appeal si Ching. The RTC rendered judgment ordering PBM and Ching to jointly and severally, meaning to be held solidarily liable, to pay Ayala Investments the principal amount with interest. And pending the appeal of the judgment, ang RTC actually issued a writ of execution. And then, ang sheriff caused the issuance, and upon service on the spouses of the notice of the sheriff's sale on the three of their conjugal properties, iyaharong gifilan sa respondent og injunction ang petitioners. Ang nitabo magud ani kay since giapil si Ching nga liable together with PBM ang iyahang properties as well as conjugal properties ni Ching giapil og birada. Okay, in order to satisfy the 50 million debt. So si spouses Ching, si Ching together with his wife ning file ron og injunction, questioning the validity of the writ of execution. Ningon sila, ang katong loan nga giutang sa PBM, it did not redound to the benefit of the conjugal partnership. So, dili malayable ang conjugal partnership kay, diba, ningon man diri, ang liable ka for the debts and obligations in paragraph 3 contracted by either parties even without the consent of the other, basta ang iyahang obligation redounded or it actually benefited the family. So ang contention ron sa spouses Ching, ingon sila pagpangutang ron sa PBM, igo raman siya nahimong garantor. So ang benefit actually did not redound sa amo ang pamilya because nagtrabaho raman di akong bana. So ang CA karon issued a TRO enjoining the lower court from enforcing its order, paving the way to the scheduled auction sale of the respondent spouse's conjugal partnership. So, ang issue here is whether or not ang loan acquired by PBM from Ayala Investments as guaranteed by Ching redounded or be considered to have redounded to the conjugal partnership or to the absolute community of property of the spouses. Muna ang pangutana. So, ningon ng Supreme Court, ang loan procured from Ayala Investments was for the advancement and benefit of PBM and not for the benefit of the conjugal partnership of Ching. Furthermore, Ayala Investments failed to prove that Ching contracted the debt for the benefit of the conjugal partnership of gains. PBM has a personality distinct and separate from the family of Ching, despite the fact that they happen to be stockholders of the said corporate entity. Clearly, the debt was a corporate debt and right of recourse to Ching as surety is only to the extent of his corporate holdings. Ningon pa gyud ang Supreme Court nga based from the foregoing jurisprudential rulings of the court, if the money or services are given to another person or entity and the husband acted only as a surety or guarantor, that contract cannot by itself alone be categorized as falling within the context of obligation for the benefit of the conjugal partnership. The contract of loan or services is clearly for the benefit of the principal debtor and not for the surety of his family. Ching only signed as a surety for the loan contracted with Ayala Investments on behalf of the PBM. And signing as a surety is certainly not an exercise of an industry or profession. It is not embarking in business. Hence, ningon na Supreme Court, the conjugal partnership should not be made liable for the surety agreement which was clearly for the benefit of the PBM. Nya, niingon pa man gyud karon ang PBM nga because of the loan, ning taas man ang iyang sweldo, naman siya dagang benepisyo. Unay argumento ron sa PBM. But ningon ng Supreme Court, we did not support or the court did not support the contention of the petitioner that a benefit for family may have resulted when the guarantee was in favor of Ching's employment, katong prolonged tenure, appreciation of the shares of stock, prestige enhanced, since ang benefits ko no contemplated in this article 96 as well as 161, because you have to read this together sa article 161 and 94 ha, kaya ang 161 provides for the conjugal partnership man. Ningon ng court, as contemplated in Article 161 of the Civil Code, must be one directly resulting from the loan. It must not be a mere byproduct or a spin-off of the loan itself. So kailangan ko no, ang benefit should be direct and not just a byproduct. Katong iyang mga benefits nga nadawat, it's not direct kaysa iya mo tong paningkamot. Just because ning loan ng PBM doesn't mean nga nakabenepisyo si Ching. So mo nay argument or reason sa Supreme Court why in this case the conjugal partnership or the conjugal property of spouses Ching was not held liable for the death of PBM. So dapat direct ang benefit nga na-obtain sa family in this case. Alright, I hope klaro to. 95, whatever may be lost kani ay sa mga hilig dira og sugal, remember whatever may be lost during the marriage and any game of chance, betting, sweepstakes, or any other kind of gambling, whether permitted or prohibited by law, shall be borne by the loser and shall not be charged to the community. Pero any winnings therefrom shall form part of the community property. Kung pilde, imuha ra ng bago kung mapilde. Kung daog, ato na sa community property or conjugal partnership of gains as the case may be. Alright? Let's now go to the ownership, the administration, enjoyment, and disposition of the community property. I want you to also read this together with Article 124 kay similar rin siya nga provision with conjugal partnership of gains. If you scan through your notes, ang 96 o 124 pareha ra siya provision. That only difference is ang 96 is under absolute community of property. Ang Article 124 is under conjugal partnership of gains. Now, may I ask Carlo to please read Article 96?
Article 96. The administration and enjoyment of the community property shall belong to both spouses jointly. In case of disagreement, the husband's decision shall prevail, subject to recourse to the court by the wife for proper remedy, which must be availed of within 5 years from the date of the contract implementing such decision. Next paragraph. In the event that one spouse is incapacitated or otherwise unable to participate in the administration of the common properties, the other spouse may assume sole powers of administration. These powers do not include disposition or encumbrance without authority of the court or the written consent of the other spouse. In the absence of such authority or consent, the disposition or encumbrance shall be void. However, the transaction shall be construed as a continuing offer on part of the consenting spouse and the third person, and may be perfected as a binding contract upon the acceptance by the other spouse or authorization by the court before the offer is withdrawn by either or both offerors.
Thank you, Carlo. So with respect to the administration and enjoyment of conjugal or community property, no, as well as conjugal property, it should be enjoyed jointly by the spouses. So sila ginanduha. But with respect to disagreement, ang decision yun sa bana ang mo prevail. Of course, subject to the recourse of the wife to proper remedy. Now, ang issue ani kasagaran nga moabot sa Supreme Court is kaning second paragraph. Okay? Kisa may makahatag na kog illustration aning second paragraph of Article 96. Kaning in the event that one spouse is incapacitated or otherwise unable to participate in the administration of the common properties, the other spouse may assume sole powers of administration. I think masabtan naman nino nga kung incapacitated or unable to participate ang usa ka spouse with respect to the administration of the common properties. Sa maning administration of the common properties. let's say naamoy paabangan, ikaw mo'y nag-manage dira nga na imong gi-administer. Kana siya, it can be exercised by the other spouse, okay? But it's limited only to the powers of administration, okay? These powers, ningon ang sunod nga sentence, these powers do not include disposition or encumbrance without authority of the court or the written consent of the other spouse. Unsa may pasabot ani? So this is with respect ani nga sentence. These powers do not include disposition or encumbrance without authority of the court or written consent of the other spouse. Correct? So, kung bisan pag ikay nag-administer Glenda unya over OFW si Carlo ron, di ka pwede makabuot-buot og prinda or baligya anang inyong building diha. Okay? Asa gyud nyo Glen sa South?
Bunga, attorney.
Sibunga. Sige, sa Sibunga, amoy building nitong Carlo. Di nimo pwede nga buot-buoto nimo og prinda or baligya ang inyong building, okay? Without the consent of Carlo. Okay, written. It has to be written. Unya, sa sunod pa gyud nga paragraph, in the absence of such authority or consent, the disposition or encumbrance shall be void. Okay? Example karon, di ka kahuwat sa SPA nga gipada karon ni Carlo or written authority nga gipada ni Carlo gikan sa let's say na siya sa Dubai kay dugay kinaabot. Imong giprinda lang gyud og dali-dali ang inyong property, ikaw ray ning pirma. Will that mortgage be considered a valid mortgage? Glenda? Under this article, no, in the absence of the authority or consent from Carlo, kanang imong encumbrance or disposition is considered void. However, strangely kaning article makalingaw because ningon siya, however, the transaction shall be construed kono as a continuing offer on the part of the consenting spouse and the third person, and may be perfected as a binding contract upon the acceptance by the other spouse or authorization by the court before the offer is withdrawn by either or both offerers. I don't know if you recall article, I think it's Article 5 of the Civil Code. Kung tanawon ha. Ang Article 5 of the Civil Code, yeah, that's correct. Ningon ang Article 5 nga acts executed against the provisions of mandatory or prohibitory laws shall be void, except kuno when the law itself authorizes their validity, di ba? Generally, kung mayroon kag void ang usa ka contract, void ang usa ka act, di man na ma-ratify. But this is the illustration or this is one of the instances wherein ang balaod niingon nga it is the law itself that authorizes the validity as provided for in Article 5. Wherein ang katong iyahang consent or katong iyahang pagbaligya shall be considered as a continuing offer on the part sa consenting spouse and that of the third person. Wherein, kung mo consent lang, kung mo ratify lang ang non-consenting spouse, nga si Carlo in this case, kato siya nga void contract will be ratified and will be considered valid. Kakuha mo? Generally, diba, dili pwede si Glenda nga magprinda-prinda sa ilang building dito sa Sibunga without the consent of Carlo. That's void. Pero ni unang balaod, kani siya nga transaction ni Glenda o let's say iyang gibaligya kang Hope, kaning transaction ni Glenda o ni Hope will be considered as a continuing offer wherein it may be perfected as a binding contract upon the acceptance of Carlo or upon the authorization of the court, as the case may be, okay? And this should be done before it is withdrawn by either or both of the offerors. Klaro na ba, guys? This is the instance wherein ang certain void transaction or void contract can actually be ratified. Kay, as you may know, kung may kag void, di man gina ma-ratify. Kay void, gani na, wakay anga i-ratify. Voidable raman ang pwedeng ma-ratify, di ba? Pareha sa marriage. You can ratify a marriage kung voidable na siya. Pero kung void, dili na gina because it's as if there's no marriage in the first place. Pero in this case, this is an example wherein the law itself authorizes the validity. wherein the transaction is considered to be a continuing offer on the part of the parties. Unya, kung mo consent na lang or kung mo ratify lang later on si non-consenting spouse, in our example, si Carlo, the said offer or said transaction will be considered valid and binding contract. I hope klaro na. Let's try to discuss this case, kaning Alejo versus Pauses Cortez, decided on June 19, 2017. Ang controversy gud ani is a parcel of land measuring 255 square meters located at Kutkot, Pulilan, Bulacan, and covered by a title. Ang property belonged to the conjugal property or absolute community of property of the respondent spouses Leonardo, okay, spouses Leonardo, and upon which their residential house was also built. It appears that sometime in March 1996, si Ricardo, papa ni George, no? Papa ni George, usa sa mga spouses Leonardo. So si Ricardo, yung papa, iyang gi-approach ang iyang igsuon nga si Dolores. Igsuon ni Ricardo nga si Dolores, sumog nag-iyaan ni George, one of the spouses, to negotiate the sale of the subject property, katong 254 square meter nga property. And accordingly, on March 29, 1996, dali ra kay no, Jacinta executed, si Jacinta, katong asawa ni George, executed a kasunduan with Dolores for the sale of the property for a purchase price of 500,000 pesos. And under the kasunduan, si Dolores was to pay 70,000 as down payment, while 230,000 is to be paid on April 30, 1996. And the remaining balance of 200,000 was to be paid before the end of the year of 1996. Ang kasunduan was only signed by Jacinta and Ricardo as the witness. Ricardo katong papa ni George, okay? Si George, however, did not sign the agreement. Now, it further appears that the down payment of 70,000 and 230,000 were paid by Dolores. So nakabayad gid siya entero og 300,000 on the dates agreed upon. And thereafter, si Dolores was allowed to possess the property and introduce improvements thereon tukod sa building. Ana. Dayon, pag July 3, 1996, on the same year, mga months thereafter lang, si George ning suwat siya letter kang Dolores, denying knowledge and consent to the kasunduan. Si George further informed Dolores that Jacinta was retracting her consent to the kasunduan due to Dolores' failure to comply with her obligations. Katong iyang balance nga 200,000 pesos. This was followed by another letter dated September 29, 1996 from George to Dolores demanding that the latter pay the balance of 200,000 pesos on or before October 5, 1996. Otherwise, kuno, ang purchase price shall be increased to 700,000 pesos. And according to Dolores, she was being compelled by George to sign the agreement, but that she refused to do so. And as a result, si George here went to her house, destroyed its water pump, and disconnected the electricity. Before the officials of the barangay, si Dolores tendered the balance of 200,000. Pero in this case, si George refused na to accept the 200,000. Instead, ang gibuhat ni George ning file siya og kaso for ejectment and annulment of sale, reconveyance, as well as recovery of possession against Dolores. So, kaning mga kasuha was actually dismissed by the trial court on technical grounds. However, during the pendency of the said cases, the subject property was sold already by George and Jacinta to respondents Cortez. Okay? Spouses Cortez. Under a deed of sale dated September 4, 1998, mga 2 years after na the transaction, for a purchase price of 700,000. So, nanay bag-o nga title na issue na sa Spouses Cortez, and then, however, ato nga time sa sale, si Dolores was still in possession of the subject property. Ang issue ra gyud nga ri kay si Dolores ningon man gud siya nga ang kasunduan kuno was already perfected and a binding contract as it was already accepted by George through his overt acts. Okay? Nakasubay man mo guys no? Katong ningon si George di nakuan na wa ko ning consenter ana. Nya ningon siya bayad sa 200,000 otherwise amo nang patas og 700,000. Nakasubay ra mo? So ningon si Dolores because atong iyang mga actuations considered na to as perfected and binding na ang contract. So niabot ni Supreme Court. Ngayon ng Supreme Court, the key issue in this case is whether the kasunduan for the sale of conjugal real property between Jacinta and Dolores as a continuing offer has been converted to a perfected and binding contract. For if George has not accepted or consented to the sale, the kasunduan is considered void, rendering the other issues raised herein merely academic. The law on Article 26 as well as Article 124 of the Family Code is therefore unequivocal when it states that the disposition of the conjugal property of one spouse without the consent or sans the written consent of the other is void. Here, it is an established fact that the kasunduan was entered into solely by Jacinta and signed by her alone. By plain terms of the law, therefore, the kasunduan is void. Ngayon na Supreme Court. Nevertheless, we agree with the RTC and CA when it held that the void kasunduan constitutes a continuing offer from Jacinta and Dolores and that George had the option of either accepting or rejecting the offer before it was withdrawn by either or both Jacinta and Dolores. The point of contention is whether George accepted such continuing offer. If so, then the kasunduan is perfected as a binding contract and otherwise the kasunduan remains void. So, niingon ng RTC nga George failure to expressly repudiate the kasunduan and his demand that Dolores comply with her undertakings show George acceptance of the sale and conjugal property. So, ni-agree ang RTC kang Dolores nga yes, katong iyang pagpadaog letter na to, kato siya is considered to be an acceptance of the sale. Pero ang CA niingon siya nga the varying terms of the kasunduan, that is in the time of the payment and the purchase price, George is deemed to have only qualifiedly accepted the same. So the Supreme Court agreed with the Court of Appeals. Ngayon ng Supreme Court, it is undisputed that after the execution of the kasunduan, George sent 2 letters to Dolores. Ang una, ngayon ng Supreme Court, informing her that he did not consent to the sale. And the other, demanding that Dolores pay the balance of the purchase price on or before October 1996, and failing which, the purchase price shall be increased to 700,000 pesos. Clearly, according to the Supreme Court, George's first letter was an outright and express repudiation of the kasunduan. The second letter, while ostensibly a demand of compliance with Dolores' obligation under the kasunduan, varied its terms on material points. That is, the date of payment of the balance and the purchase price. Consequently, such counteroffer, ningon ng Supreme Court, such counteroffer cannot be construed as evidencing George's consent to or acceptance of the kasunduan. For it is settled that where the other spouse's putative consent to the sale of the conjugal property appears in a separate document which does not contain the same terms and conditions in the first document signed by the other spouse, a valid transaction could not have arisen. So kailangan it should be in the same kasunduan nunta ang acceptance ni George. So in this case, ningon na Supreme Court, katong yung separate letters, it will not be considered an acceptance. So ang sale in this case was considered void by the Supreme Court. But later on, discovers the Supreme Court nga Dolores in this case was in good faith. So the parties here, spouses, isa to spouses gani, pangasa tong spouses Leonardo was ordered or were ordered by the Supreme Court to refund Dolores the amount that she already paid to Jacinta in this case, in the amount of 300,000 pesos. If you want to, neither can George's subsequent letters to Dolores be treated as a ratification of the kasunduan for the basic reason that a void contract is not susceptible to ratification. Nor can George allege participation in the negotiation for the sale of the property or his acquiescence to Dolores' transfer to and possession of the subject property be treated as converting. Such continuing offer into a binding contract, as the law distinctly requires nothing less than a written consent to the sale for its validity. Suffice to say that participation in or awareness of the negotiation is not consent. So this is actually to answer your question earlier, Carlo, no? Nga it has to be in a written, it has to be in a form of a written consent. So, naku-isulti gani ha, ba't nakalimot ko? Anyway, mo na siya. If you want to, read the entire case, basahan lang ninyo ang full text, ani ha, makita na ninyo sa internet. That's the case of Alejo versus Pastos Cortez, decided on June 19, 2017, with GR number 206114. Alright? Klaro na, guys?
Yes, attorney.
Yes, attorney.
Okay, thank you. Article 97, 98. Basically, these are matters of reading. Basahan ninyo guys ha. Article or Section 5, dissolution of absolute community regime. Kano saan man ma-terminate ang absolute community? Una, either by the death of either spouse, of course, kung mamatay na ng usa, wala na may marriage, wala na absolute community of property. So, also, if there's a decree of legal separation, because kung nanay decree of legal separation, it also, commonly, it also follows that there is also a separation of property. So, ma-terminate ang absolute community property. Also, when the marriage is annulled or declared void, or in case of judicial separation of property provided for in Articles 134 to 138. Okay? May I ask Glenda to please read Article 100, please.
Article 100, attorney. The separation, in fact, between husband and wife shall not affect the regime of absolute community, except that, first, the spouse who leaves the conjugal home or refuses to live therein without just cause shall not have the right to be supported. Second, when the consent of one spouse to any transaction of the other is required by law, judicial authorization shall be obtained in a summary proceeding. And third, in the absence of sufficient community property, the separate property of both spouses shall be solidarily liable for the support of the family. The spouse present shall, upon proper petition in a summary proceedings, be given judicial authority to administer or encumber any specific separate property of the other spouse and use the fruits or proceeds thereof to satisfy the latter's share.
Thank you, Glenn. Timan guys, nga bisan magbuwag mo sa imong asawa baron or sa imong bana, kung sa inyong property regime, it will not be affected. Meaning, bisan pag buwag na mo, if you were earning so much compared to the moment where you were still living together with your husband or your wife, kana siyang imong earnings will still form part of the absolute community. Okay? And except the separation in fact between the husband and the wife shall not affect the regime of absolute community except lang kuno to the spouse who lives the conjugal home or refuses to live therein without justifiable or without just cause, shall have no right or shall not have the right to be supported. Di siya pwede nga mangayog support sa iyahang bana kung siya mismo ning layas, di ba? So if there's no just cause, of course. Also, when the consent of one spouse to any transaction of the other is required by law, pwede kang mangayo sa korte o authority in a summary proceeding. Also, in the absence of sufficient community property, the separate property of both spouses shall be solidarily liable for the support of the family. The spouse present shall, upon proper petition in summary proceeding, be given judicial authority to administer or encumber any specific property or separate property of the other spouse and use the fruits or proceeds thereof to satisfy the latter shares. Suppose dissipated na ang funds sa absolute community, wa na ginahabilin, wa na matiti, ang nabilin na lang ang separate property sa katong nangabit or katong ning layas. Pwede na nimong i-administer, pwede nimong i-encumber, but you have to ask authority from the court. Okay? Moro na ipasabot aning paragraph 3, article 100. Now, article 101, again, read this together with article 128. wherein it provides that if a spouse without just cause abandons the other or fails to comply with his or her obligations to the family, the aggrieved spouse may petition the court for receivership, for judicial separation of property, or for authority to be the sole administrator of the absolute community, subject to such precautionary conditions as the court may impose. Okay? The obligations to the family mentioned in the preceding paragraph refer to marital, parental, and property relations. Now, kanus aman ka makakonsider nga gi-abandon? Niingon ang Article 101, paragraph 3 nga, a spouse is deemed to have abandoned the other when her or she has left the conjugal, when he or she has left the conjugal dwelling without intention of returning. Okay? The spouse kuno who has left the conjugal dwelling for a period of 3 months or has failed within the same period to give any information as to his or her whereabouts shall be prima facie presumed to have no intention of returning to the conjugal dwelling. Mura nagi-ghost ka ba? Kanang nakay ka-chat niya, gi-ghost ka, mga 3 months na kapin, wala ning chat ni mo. Ano lang pa-expect nga mo balik na? Ang presumption na under the law, gi-abandon na ka. Para nas bana, if ang bana or asawa kalitrag kahanaw, within 3 months or in a period of 3 months or more, wa gyud nagparamdam, bisag text man lang or chat man lang or pangumusta, wa gyud. Ang presumption na under the law, you have already been abandoned by that particular spouse nga nibiya sa imuha. Ang pasabot ana, wala na siya intention to return to the conjugal dwelling. And if that happens, you can always ask the court to be the sole administrator of the absolute community. Or you can also ask the court for judicial separation of your property, as well as receivership. Okay? Now, kanidi ay, ang Partosaho versus CA, niingon nga abandonment implies a departure by one spouse with the avowed intent never to return, followed by prolonged absence without just cause and without, in the meantime, providing in the least for one's family, although able to do so. There must be absolute cessation of marital relations, duties, and rights with the intention of perpetual separation. The idea is clearly expressed in the above quoted provision, which states that a spouse is deemed to have been abandoned the other when he or she has left the conjugal dwelling without the intention of returning. All right? So, ang nahitabo man ani kay ning larga, I think nilarga ang bana. Let's see. The record shows in this case that as early as 1942, ang respondent had already rejected the petitioner whom he denied admission to the conjugal home in Dumaguete City when she ning uli dai ni siya sa Sambuanguita nya taga Dumaguete ni sila, pero si asawa in this case, let's say si Glenda, wanted to go home na from Sambuanguita, ning bisita ra gud siya sa Sambuanguita sa pamilya. Pag uli niya wala siya gipasod ni Carlo sa ilang balay sa Dumaguete. So ningon na Supreme Court, the fact that she was not accepted by Ho in this case demonstrates all too clearly that he had no intention of resuming their conjugal relationship. Moreover, beginning 1968 until the determination of this court of the action for support in 1988, the private respondent refused to give financial support to the petitioner. The physical separation of the parties, coupled with the refusal by the private respondent to give support to the petitioner, suffice to constitute abandonment as a ground for the judicial separation of their conjugal property. Because in this case, Manggod, si Mrs. Glenda asked for the judicial separation of their conjugal property nila ni Carlo. And ningon Manggod diri si Carlo nga there was no abandonment. But ang gi-raise dito ni Glenda, there was abandonment because when I returned home, wa na gyud ko nimo pabalika, bisag yun sa nako balik-balik, di na ko nimo pasudlon. So in this case, ningon na Supreme Court justified ang petition nga gi-file in this case ni Glenda for the judicial separation of their conjugal property because it is presumed that Glenda in this case was already abandoned by Carlo. So if you want to read the entire text of this case, read Partosaho versus Court of Appeals, decided on December 18, 1992, dealing with the concept of abandonment under Article 101 and 128 of the Family Code. Right? So, unsa man ang kaning 102, 103, basahan lang na ninyo guys ha, masabtan na ninyo. And unsa may mo comprise conjugal partnership of gains. As mentioned earlier, under the regime of conjugal partnership of gains, the husband and wife place in a common fund the proceeds, the products, the fruits, and the income from their separate properties, okay? And those acquired by either or both spouses through their efforts or by chance. And upon dissolution of the marriage or of the partnership, the net gains or benefits obtained by either or both spouses shall be divided equally between them unless agreed upon in the marriage settlement. So, mao na siya ang conjugal partnership of gains. Lahi kayo siya sa absolute community of property. Ingon sila kung nahigugma jud kuno ka sa tao, wa na ka din na ka mag settlement oy. Diretso na under the family code mag absolute community of property na ka because you are not thinking na you will be separated no from your spouse. Kay gugma gud ka. So wanay prenup kay tungod sa gugma. Kung wa ka nahadlok nga magbuwag mo, go for absolute community of property. But if you want to protect your property, choose either complete separation of property or conjugal partnership of gains. Depende nimo, okay? Article 107 to 148 are matters of reading, basically reiteration of some of the provisions in absolute community of property. Ang katong complete separation of property, wala kayo nang gawas ato, but basically, maura to siya, ija-ija, aho-aho ang concept. But in order for you to have a better grasp of the concepts, basahan lang sa ninyo ang articles governing complete separation of property. Okay? Whew. Let's go now to the provisions on family. The family as an institution. The family, kailan mo kisay mga membro sa inyong pamilya. Masigsige na magsag-o sa provisions sa anang grounds for nullity of marriage and all that you could not recall the members of your family. Anyway, the family being the foundation of the nation is a basic social institution which public policy cherishes and protects. Consequently, family relations are governed by law and no custom, practice, or agreement destructive of the family shall be recognized or given effect. Nindot kay pagka-istorya, no? And then the family relations include those between husband and wife, parents and children, among brothers and sisters, whether full or half-blood. Timan isad under Article 151 nga no suit between members of the family shall prosper unless it should appear that verified complaint or appear from the verified complaint or petition that earnest efforts toward a compromise have been made, but the same have failed. If it is shown that no such efforts were in fact made, the same case must be dismissed. This rule shall not apply to cases which may not be subject to compromise under the Civil Code. And sa manginganong kinahanglan man na, it is necessary that every effort should be made toward a compromise before a litigation is allowed to breed hate and passion in the family. It is believed man good nga a lawsuit between close relatives generates deeper bitterness than between strangers. Lahi na kayo kung imong kabangi kay imong pamilya as opposed kung imong kabangi is stranger to you, di ba? That's why the law requires that there should be an effort toward a compromise. And kailangan nimo iprobar nga compromise is no longer feasible before a case may proceed to trial or litigation, as the case may be. Family home. Family home is constituted jointly by the husband and by the wife or by an unmarried head of the family. This is the dwelling house where they and their family reside and the land on which it is situated. The family home under Article 153 is deemed constituted on a house and lot from the time it is occupied as a family residence. From the time of its constitution and so long as any of its beneficiaries actually resides therein, the family home continues to be such and is exempt from execution. Exemption from execution, ha? For sale or attachment, except as hereinafter provided and to the extent of the value allowed by the law. Kani example, si Glenda and Carlo are married. They constituted a family home in the lot owned by Sir Bon. Okay? Nang-abang sila sa yuta ni Sir Bon. Sa yuta ni Sir Bon, nagtukod sila dito og conjugal dwelling. Dito sila nagpuyo, dito nila gimatuto ang ilang mga anak. Karon suppose nakautang si Carlo o si Glenda in the amount of, say, 1 million. And wa sila kabayan, okay? Pwede ba nga biradahon sa creditor, let's say nakautang sila sa PNB, okay? Pwede ba nga biradahon or i-execute sa PNB ang balay nga gitukod ni Carlo and Glenda sa yuta ni Sir Bon? The question is, can Glenda and Carlo invoke the exemption under Article 153 on the ground that the building or the house constructed on the lot of Sir Bon is actually a family home? The answer is no. Okay? Nga naman, because a family home must be instituted or constituted as the dwelling house where they and their family live, and it should be on the land on which it is situated. Simply put, it has to be owned by the spouses, okay, both the house and the lot. Meaning, in order to be covered under Article 153, kaning exemption, kailangan owned nila both ang lot o ang building. If dili gani, dili na siya exempt from execution. Also, ikaduha, katong gimension ganihan ni Erwin, if daghan silag mga balay-balay, bisag ilaha pa ng yuta, if the spouses cannot establish that that particular house nga gi-execute sa PNB nga ilang nautangan is not their family home, pwede gihapon nang ma-execute. Another instance, kung na sila'y mortgage and gihimong collateral is the house and lot, okay, the family home supposedly, ang ilang gihimong collateral over the mortgage, kana pwede na siyang ma-execute. Pero with respect to the question earlier, ang ako arang gipangutana is, can there be an exemption over the house or over the building nga gi-construct ni Carlo o ni Glenda sa yuta ni Sir Bon? The answer is no. There's no exemption. Because the rule is, kailangan both house and lot are owned by the spouses. Either it is a conjugal property or an absolute community of property of both spouses. Klaro ra, guys? So to answer the question said of, klaro ra ba?
Yes,
Sabot ra mo, kailangan
Yes,
own
attorney.
of both house and lot para mo sud ang exemption. Para mo tuo mo nako, it's actually stated in the case of Cabang versus Basay. The Supreme Court said that the family home must be part of the properties of the absolute community or the conjugal partnership or the exclusive properties of either spouse with the latter's consent on the property or on the property of the unmarried head of the family. In other words, the family home must be established on the properties of either the absolute community or the conjugal partnership or the exclusive property of either spouse with the consent of the other. It cannot be established on the property held in co-ownership with third persons. However, it can be established partly in community property or conjugal property and partly in the exclusive property of either spouse with the consent of the other. Basta ilahag yun ang property dapat, okay? If constituted by an unmarried head of the family, let's say single siya pero siya ang head of the family, it should also be where there is no communal or where there is no communal or conjugal property existing. It can be constituted only on his or her own property, meaning it has to be owned good by the owner of the home. So ang yuta should be the lot should be owned by the spouses or by the unmarried head of the family before ka maka-invoke any exemption under Article 153. Okay? So, ang beneficiaries, kinsa may beneficiaries sa family home, ang husband, klaro ra ba guys? Before I proceed, I just would like to clarify if naklaro to.
Yes, attorney.
Okay, thank you. Now, the husband and the wife are the beneficiaries of the family home, or the unmarried person who is the head of the family, and their parents, ascendants, descendants, brothers and sisters, whether the relationship be legitimate or illegitimate, who are living in the family home and who depend upon the head of the family for legal support. Now, you mentioned earlier the instances wherein the exemption from execution will not apply, katong non-payment of taxes. Of course, wag gid kay panguntraan ng gobyerno. When it comes to taxes, di gid na nimo ma-invoke nga, oh, family home ni, dili ni ma-levy sa government. No, it cannot be, because it's one of the exceptions provided for in Article 155. Also, mga utang nga na-incur prior sa pagtukod anang family home, dayon debts nga gisecure sad by mortgages, katong gi-mention gid Doc Judith, kato siya ang instance aning debt secured by mortgages on the premises before or after such constitution, and for debts due to laborers, pagtukod nimo anang balaya na pwede kay mga wa na sweldo eh. So basically, kung maningil na sila nga tos dole, pwede nang, kung wakailaing property, pwedeng ma-execute ang imong family home in order to pay these laborers, these mechanics, architects, builders, material man, and others who have rendered service or furnished material for the construction of the building. All right? Now, 156 on sa mani, can you read Article 156, Glenda, in 157? Thank you.
Article 156, the family home must be part of the properties of the absolute community or the conjugal partnership, or of the exclusive properties of either spouse with the latter's consent. It may also be constituted by an unmarried head of the family on his or her own property. Nevertheless,
sorry Glenda ha. Mao na siya itong gi-mention ganiha sa case ni Cabam versus Basay, okay? Ayon, yes Glenda, nevertheless.
Nevertheless, property that is the subject of a conditional sale on installments, where ownership is reserved by the vendor only to guarantee payment of the purchase price, may be constituted as a family home. Article 157, the actual value of the family home shall not exceed, at the time of its constitution, the amount of 300,000 pesos in urban areas and 200,000 pesos in rural areas, or such amounts as may hereafter be fixed by law. In any event, if the value of the currency changes after the adoption of this code, the value most favorable for the constitution of a family home shall be the basis of evaluation. For purposes of this article, urban areas are deemed to include chartered cities and municipalities whose annual income at least equals that legally required for chartered cities. All others are deemed to be rural areas.
Okay, so basically, mauna yung gipag-mention earlier with respect to the value, no? There's a ceiling with respect to the value up to 300,000 for urban areas and 200,000 pesos in rural areas. Beyond that, dili na siya exempt from execution. Ang exempt lang niya is only up to the amount of 300 or 200, as the case may be, depending on whether it is urban or a rural area. Now, let's now continue our discussion. I want you to just read Articles 158 to 162. These provisions are matters of reading. No, we've discussed the salient points of family home under this chapter. We now proceed to paternity and affiliation. On Chapter 1, it provides for legitimate children, or laws governing legitimate children. The filiation of children under Article 163 may be by nature or by adoption. Natural filiation may be legitimate or illegitimate. Now, kinsa may considered nga legitimate children? Under Article 164, children conceived or born during the marriage of the parents are legitimate. Okay? If they're born or conceived gisabak or natao during sa kaminyuon, sa ginikanan, they're considered legitimate children. Okay? Ang legitimate children as a result of artificial insemination of the wife with the sperm of the husband or that of a donor or both are likewise legitimate children of the husband and the wife, provided that both of them authorized or ratified such insemination in a written instrument executed and signed by them before the birth of the child. The instrument shall be recorded in the civil registry together with the birth certificate of the child. Okay? So the family code already recognized artificial insemination as a means of conceiving a child. Okay? The child conceived and born by reason of artificial insemination will be considered a legitimate child so long as there is a written authority. Kailangan written instrument executed and signed by the parties before the birth of the child. Unya, kana nga instrument nga gisignan sa managtiayon shall be recorded in the civil registry together with the birth certificate of the child. Also remember that children conceived and born outside of valid marriage are illegitimate unless otherwise provided in this code. The presumption actually is legitimacy of children. But you have to remember nga kaning presumption does not only flow out of a declaration in the statute but is based on the broad principles of natural justice and the supposed virtue of the mother. The presumption is grounded on the policy to protect the innocent offspring from the odium of illegitimacy. This is what the Supreme Court said in the case of Cabatania versus Court of Appeal. So ang presumption, no, kung naimatao nga bata, the presumption is legitimate na siya nga bata, okay, unless otherwise proved by the person who will impugn the legitimacy of the child. But basically, ningon ng Supreme Court, kaning presumption di lang na siya because ningon ng balaod ha, it is based on broad principles of natural justice and the virtue of the mother. Okay. Now, kanus-aman ka pwedeng maka-impugn sa legitimacy sa usa ka bata. Kanus ani mo ma-question nga kanang bata di man nako anak bisag minyo mo, mayong ka di man nako anak. Legitimacy of a child may be impugned only on the following grounds. Una, anak, it was physically impossible for the husband to have sexual intercourse with his wife within the first 120 days of the 300 days which immediately preceded the birth of the child because of, una, physical incapacity of the husband to have sexual intercourse with his wife. Let's say, napriso ang bana. Unya, walay, unsa nang tawag gani ka ng visitation sa kuan? Conjugals. There's no conjugal visitation. And then nabuntis kalit imong asawa. There was no contact whatsoever. Nya, priso imong bana. Pwede na ma-impugn sa bana ang legitimacy sa child if mabuntis ang asawa. Ikaduha, the fact that the husband and the wife were living separately in such a way that sexual intercourse was not possible. Naros gawas sa nasod ang bana. Unya, diri ang asawa na buntis. That's basically a ground. Also, serious illness of the husband, which absolutely prevented sexual intercourse. Let's say, usa ka guys, ang illness sa usa ka bana nga maka-prevent you from performing in bed or having a sexual intercourse with your wife. Can you think of an illness? Of
Impotence.
Impotence. Yeah, the permanent impotence. Yeah. Kana, unsa pa? Kanang na tuberculosis. Will it prevent the husband from having sexual intercourse with the wife if the husband is suffering from tuberculosis? There was one case, no?
Ang AIDS. Kanang AIDS, attorney. Na AIDS.
AIDS. Pwede rin po na makipag-chungkang Seth, bisag na AIDS.
When about kanang paralyzed attorney?
Yeah, kanang paralyzed and incapable good siya of, what do you call this? Kanang na siya power failure, basta yung power failure kay because of the serious illness. Basically, impotence, permanent impotence of the husband, okay? But tuberculosis, the Supreme Court would say, dili na siya ground para makaingon ka nga that's a serious illness of the husband that would prevent him from having sexual intercourse because in the past, kuno, there's been a study na mas kuan kuno na sila, mas active sexually when it comes to the pleasures in bed, kanang may mga sakit nga kanang pirmi nga nakahigda ba. So basically that's not a ground if you are suffering from tuberculosis, kanang grave or serious tuberculosis, severe tuberculosis. But anyway, if there's physical incapacity on the part of the husband to have sexual intercourse with the wife, or naglive sila separately in such a way that sexual intercourse was not possible, or there be serious illness of the husband, kana siya, the husband can always impugn the legitimacy of the child, okay? Or that it is proved that for biological or other scientific reasons, the child could not have been that of the husband, except in the instance provided for in the second paragraph of Article 164, kato in artificial insemination. Also, in case of children conceived through artificial insemination, wherein the written authorization or ratification of either parent was obtained through mistake, fraud, violence, intimidation, or undue influence. All right? Now, in the case of conception versus conception, yung Supreme Court, the presumption of legitimacy proceeds from sexual union in marriage, particularly during the period of conception. To overthrow this presumption on the basis of Article 161, Paragraph 1, particularly subparagraph B of the Family Code, it must be shown beyond reasonable doubt that there was no access that could have enabled the husband to father the child. Sexual intercourse is to be presumed where personal access is not disproved unless such presumption is rebutted by evidence to the contrary. Kani manggod nga case in conception versus conception, basically, buwag na tuod sila, apan yang bana, silingan ra sila og taon ba? So, ningon ng Supreme Court, the presumption is quasi-conclusive and may be refuted only by evidence of physical impossibility of coitus between husband and wife within the first 120 days of the 300 days within immediately preceded or which immediately preceded the birth of the child. To rebut the presumption, the separation between the spouses must be such as to make marital intimacy impossible. This may take place, for instance, when they reside in different countries or provinces as they were never together during the period of conception, or the husband was in prison during the period of conception unless it appears that sexual union took place through the violation of prison regulations. So basically, ang presumption of regularity may be overthrown by showing that there was really no marital, or if it can be shown that marital intimacy was really impossible. And mao ni ang mga instances nga gisay sa Supreme Court. Separate ilang places, or lagyo sila, nya wagin sila nakita, or napriso baron ang bana, unya there couldn't be any sexual intercourse without violating prison regulation. So that's the case of conception versus conception. Basahan ninyo ang full text ana to have a better understanding of this case. But basically, ang presumption is always with respect to the legitimacy of the child. Now, Article 167, the child shall be considered legitimate through the mother, though the mother may have declared against its legitimacy or may have been sentenced as an adulteress. Okay? That's always the presumption. Ang una-unaon magana good kay ang bata, ang status sa bata sa katilingban. Alright? Ang Article 168 sad, naghatag nato sa status sa bata in case the marriage is terminated and the mother contracted another marriage within 300 days after the termination of the former marriage. So unsa may rule nga mo govern? Kung a child is born 180 days after the solemnization of the subsequent marriage is considered to have been conceived during the former marriage, provided it be born within 300 days after the termination of the former marriage. So may example ana, kani, a widow married 100 days after the death of her first husband. Unya, a child was born to her 170 days after the celebration of the second marriage. Ang status sa bata ana is legitimate child of the first husband. Nganuman, nataw man ang bata within 180 or before 180 days after the solemnization of the subsequent marriage. Unya, nataw pagid siya within 300 days. Kakuha mo, 300 days after the termination of the former marriage. Kitanawa, i-add ninyo ang 100 o 170. That's basically less than 300. Now, letter B provides a child born after 180 days following the celebration of the subsequent marriage is considered to have been conceived during such marriage, even though it be born within 300 days after the termination of the former marriage. Example, nabiyuda na si Glenda, and then nagminyo siya kang after, let's say, 100 days, nagminyo siya kang Carlo. And then, after the celebration of the marriage, let's say, mga pag-abot na og 200 days after the celebration of the marriage, nanganak si Glenda. Kinsa man tong anak? Anak ba to sa iyang unang bana or sa iyang unang asawa? Ay, unang asawa. Unang bana or sa ikaduhang bana nga si Carlo? Kisa tong anak.
After 100 days, attorney?
After 200 days na following the celebration of the marriage.
Still, I think attorney, still on her first husband, attorney. Because it's still...
Awa, nagminyo si Glenda Alvin after 100 days sa kamatayon sa iyang bana. Okay? Mingaw naman siya. Mingaw siya na. So, after 100 days, kita siyang Carlo. Minyo sila. Karon, after 200 days sad from the celebration of their marriage, after 200 days, nanganak si Glenda. Kisam tong anak? Ang gianak ni Glenda after 200 days following the celebration of the marriage.
Considered na attorney sa iyang bago. Second husband, attorney.
Yes.
Yes.
9 months times 30 days, 180.
Second marriage, attorney.
Ha? Second marriage. Second marriage na guys ha. Ngayon man din sa paragraph 2, a child born after 180 days following the celebration of the subsequent marriage is considered to have been conceived during such marriage, even though it be born within 300 days after the termination of the former marriage. Okay? Kuha na ba? Inyo ram ning balikon, makuha rin ninyo. Okay? So the legitimacy or the illegitimacy of the child born after 300 days following the termination shall be proved by whoever alleges such legitimacy or illegitimacy. Right? Now on to the action to impugn the legitimacy of the child. Timan-i nga naay prescriptive period, okay? When you want to impugn the legitimacy of the child, it should be brought within 1 year from the knowledge of the birth or its recording in the civil register. If the husband, or in proper case, any of his heirs, reside in the city or municipality where the birth took place or is recorded. So kung same lang mo municipality, 1 year. Kung ang husband or ang iyang heirs do not reside in the same place, ang prescriptive period shall be 2 years. Okay? If they should reside in the Philippines. Pero kung abroad sila nagpuyo, that should be 3 years. Pero if the birth of the child has been concealed from or was unknown to the husband or his heirs, the period shall be counted, of course, not from the birth, but from the discovery or knowledge of the birth of the child or the fact of registration of the said birth, whichever is earlier. Okay? Now, the heirs of the husband may impugn the filiation of the child within the period prescribed in the preceding article only in the following cases. Una, if the husband should have died before the expiration of the period fixed for bringing his action. Di man ha? Makasudra ng mga heredero sa bana kung namatay siya before the expiration of the period provided for in Article 170, 1 year, 2 years, or 3 years as the case may be. Or if he should die after the filing of the complaint without having desisted therefrom. After the file of the complaint, namatay, so mo substitute ang iyang mga heredero. Or if the child was born after the death of the husband. O kung kana pa diha na tao ang bata after na sa kamatayon sa bana, pwede diha ang mga heirs niya maka-question or maka-impugn sa legitimacy sa child. Okay? Now, how do you prove filiation? The filiation of legitimate children is established by any of the following: the record of birth appearing in the civil register or final judgment. Kaniha, in this instance, you have to remember nga, kanabitang record of birth must be signed by the father. Dili ka pwede nga magbutang-butang niya kinsay papa kung tanaw ni mo, pinakagwapo na kong classmate si Seth man, si Seth Dispues man, sila ko ibutang diri nga papa sa kong anak eh. Without the knowledge of Seth and without the signature of the Seth, kana nga pagbutang nimo being the father of the child, being the legitimate father of the child will not have any bearing because the same must be signed by the father. This provided for in Rosses versus LCR, okay? Also, an admission of legitimate filiation in a public document or private handwritten instrument and signed by the parent concerned. Example, naamoy mga series of correspondence sa imong anak, bangin mo anak, ikaw jud ang pinakapinangga na kong anak, bisan pa man sa muna kana. These are proofs of filiation, kana series of correspondence nimo between your child or your correspondence with your supposed father, okay? In the absence of the foregoing evidence, the legitimate filiation shall be proved by open and continuous possession of the status of a legitimate child. Known kada sa community nga anak ka ni Seth, and yeah, any other means allowed by the rules and special laws. Pwede mga testimony from your kaila who can actually say nga kana siya kay legitimate child, magina siya anak niya. Because gibuhi mo gina siya anak niya and diha jud ko pagkatao kita jud ko niya anak, all that. Kana sad siya guys, musud lang ning second paragraph or kaning secondary evidence if walay record of birth, walay admission of legitimate filiation in either a public document or private handwritten instrument signed by the parent concerned. Okay? The action to claim timan nga ang action to impugn the legitimacy na prescriptive period. Pero ang action to claim legitimacy may be brought by the child during his or her lifetime and shall be transmitted to the heirs should the child die during minority or in a state of insanity. Okay? So during the lifetime sa bata, makapangutana gyud siya no, maka-claim gyud siya no, makaingon gyud siya nga pa ang kuna ko nga imo kong legitimate nga anak, ayaw kong isalikway kana during siyang lifetime. This right will only be transmitted to the heirs of the child if he or she dies during minority or during a state of insanity. In these cases, guys, the heirs shall have a period of 5 years within which to institute the action. Okay? Lahi sa bata, kay ang bata, imprescriptible man. Pero kung na-transmit na niya katungod nga to sa heredero, ang prescriptive period is 5 years. Alright? Ang legitimate children, mo ning mga katungod nila, the right to bear the surnames of the father and the mother in conformity with the provisions of the Civil Code and surnames, to receive support from the parents, their ascendants, and in proper cases, their brothers and sisters in conformity with the provisions of this code and support, and to be entitled to the legitimate and other successional rights granted them by the Civil Code. Moning mga katungod sa legitimate children. All right? Let's now go to the provisions on illegitimate children. Kisa tong illegitimate children ato na itong nahisgutan ganiha, di ba? But illegitimate children may also establish illegitimate filiation in the same way and the same evidence as legitimate children. Katong atong gi-mention earlier, kaning record of birth, admission of the legitimate filiation, so pwede nilang magamit as evidence to prove illegitimate filiation to their father. Okay? Illegitimate children shall use the surname and shall be under parental authority of their mother and shall be entitled to support in conformity with this code. The legitime of each illegitimate child shall consist 1/2 of the legitimate child. Except for this modification, all other provisions of the Civil Code governing successional rights shall remain in force. Sa una, kay gamay ra mag-share ang illegitimate, unya gi-classify pagid nila ang klase-klase sa mga illegitimate, na mga putative, nga. But karon the law does not distinguish anymore kung kinsa na nga klase nga illegitimate child, okay? As long as born siya outside of wedlock, kanang bata illegitimate, and under the law entitled siya to 1/2 of the legitimate child. This was amended by RA 9255. Ningon diri ang RA 1255. Illegitimate children shall use the surname and shall be under the parental authority of the mother and shall be entitled to the support in conformity with this code. However, illegitimate children may use the surname of their father if their filiation has been expressly recognized by their father through the record of birth through the record of birth appearing in the civil registrar, or when admission in a public document or private handwritten instrument is made by the father, provided that the father has the right to institute an action before regular courts to prove non-filiation during his lifetime. The legitime of such illegitimate child shall consist 1/2 of the legitime of the legitimate child. Okay, that's the amendment in Article 16 or 176. So pwede nga ang bata makagamit sa apelido sa papa as long as he is recognized by the father. Alright? Kaning grande day guys versus Antonio, ang issue lang here is the right of the father. Iya man gipugusgod nga kanang pagamiton sa iyang apelido ang iyahang illegitimate nga child. Pero di man sila ganahan nga mogamit. So, ang central core or ang central to the core issue is the application of Article 176 of the Family Code, originally phrased aning atong gisgutan, di ba? So, niingon ang Supreme Court, Article 176 gives illegitimate children the right to decide if they want to use the surname of their father or not. It is not the father or the mother who is granted by law the right to dictate the surname of their legitimate children. Nothing is more settled than what the law is clear and free from ambiguity. It must be taken to mean what it says, and it must be given its literal meaning, free from any interpretation. The respondent's position that the court can order the minors to use his surname therefore has no legal basis. Ningon pa ng Supreme Court on its face, kaning article as amended is free from ambiguity. And where there is no ambiguity, one must abide by its words. And the use of the word may in the provision readily shows that an acknowledged illegitimate child is under no compulsion to use the surname of his illegitimate father. The word may is permissive and operates to confer discretion upon the illegitimate children. So it is not up to the mother or to the father kung unsa iyahang gamiton nga apelido. It is up to the illegitimate children if they want to use the surname of the father. Otherwise, they should be allowed to continuously use the surname of the mother. Mao na ang kaso sa Grande versus Antonio. Note of the amendment guys sa Article 176 mentioned earlier. Legitimated children. Kinsa man ning mga legitimated children? Kabaw na kakisay legitimate children, di ba? Conceived or born during the marriage of the parents. Illegitimate, born outside of the marriage of the parents, kanang outside the wedlock. Legitimated sad, mo ni sila ang children conceived and born outside of wedlock of parents who at the time of the conception of the former were not disqualified by any impediment to marry each other, or were so disqualified only because either or both of them were below 18 years of age, may be legitimated. Kani ko no example. During sa conception and birth of the child of Glenda and Carlo, ang edad ni Carlo is 17, si Glenda was 16. Okay? When they conceived the child, ang pangalan sa child, ibutang lang si Erica. Pag panganak nila kang Erica, ang edad nila 17 and 16 respectively. Karon when they attain the age of majority, pag abot na ron nag-18 nilang 18 ni Glenda niya, pag 19 na ni Carlo, nagpakasal sila. Question, can the child be considered a legitimated child? Can the child, Erica, be considered a legitimated child? Sa una, before the amendment, kuan rani ang provision sa 177 mo rani, only children conceived and born outside of wedlock of parents who at the time of the conception of the former were not disqualified by any impediment to marry each other. Wala ning or were so disqualified only because either or both of them were below 18 years of age. Gi-add na lang ni nga ang reason sa impediment is minority. So if ang reason sa impediment is minority, pwede nga upon the marriage of the parents, malegitimated ang bata. Kani ko no, example Val, is if ever nag-ipon si Glenda, let's say si Glenda is married to you, pero nakig-ipon siya ni Carlo. Mas love niya si Carlo kay kanimo Val. During sa cohabitation ni Glenda og ni Carlo, naka-bear sila og child. Ang pangan sa child kay si Erica. Karon, example lang, simba ko lang yun, Val. Dili lang ikaw, example ba, si X lang. Example si X, mo taliwan, okay? If suppose si X dies, okay? X dies. And karon is uy, free na gyud ta to get married in town, my love Carlo. So karon nagpakasal si Carlo ug si Glenda. Pwede ba nga ma-legitimated? Can Erica be legitimated by reason of the marriage of Glenda and Carlo?
And based on my own opinion, it's not automatic. However, they can file for the they can file. I forgot what to file, but to be legitimated attorney, but it's not automatic upon the marriage. But they can file. No, it's an adoption. Yeah, it's an adopt. You need to adopt. You need to adopt.
Okay. So Erica in this case cannot be legitimated. Cannot be legitimated because di siya mo qualify aning Article 177, di ba? Kaya ang Article 177 provides nga only children raman conceived and born outside of wedlock of parents who at the time of the conception of the child were not disqualified by any impediment to marry each other. During the conception of Erica, the partners Glenda and Carlo were disqualified man, di ba? Because of an impediment. O sa may impediment ato, married pa man si Glenda at the time of the conception of Erica. So di gyud ma-legitimated si Erica. If they want to confer legitimate status over Erica, they will have to adopt Erica and not by virtue of the action for legitimation of the child. Okay? Basically, Article 178 provides that legitimation shall take place by subsequent valid marriage between the parents. The moment nga magpakasal na sila, under the law, they are considered legitimated. Okay? Ang annulment of the voidable marriage shall not affect the legitimation. Also, kung may legitimated children, pareha na silang status sa legitimate child. Okay? The effects of legitimation shall also retroact at the time of the child's birth. And if you want to impugn the legitimation, this may be done within a period of 5 years from the time their cause of action accrues. Now, I'd like to discuss in passing the concept of domestic and intercountry adoption. Okay. When we talk about adoption, guys, adoption is a juridical act. Maklaro na no akong screen?
Yes,
attorney. Yes, attorney.
Thank you. Which creates between two persons a relationship similar to that which results from legitimate paternity. Ang adoption is a juridical act. This is a proceeding in rem which creates between two persons a relationship similar to which results from legitimate paternity and affiliation. Now, we've mentioned this. We also have the so-called intercountry adoption. When we talk about intercountry adoption, this refers to the socio-legal process of adopting a Filipino child by a foreigner or a Filipino citizen permanently residing abroad where the petition is filed. The supervised trial custody is undertaken and the decree of adoption is issued in the Philippines. Now, let's distinguish domestic from intercountry adoption. When we talk about domestic adoption, this is governed by RA 8552. And when we talk about intercountry adoption, this is governed by RA 8053, the Intercountry Adoption Act of 1995. Ang domestic adoption applies to domestic adoption of Filipino children where the entire adoption process beginning from the filing of the petition up to the issuance of the adoption takes place in the Philippines. Mao ni siya ang adoption nga naa diri sa ato kanang di mo ka anak and then you want to adopt. That's the so-called domestic adoption. When we talk about intercountry adoption, this applies to adoption of a Filipino child pero dito sa foreign country. Dadun siya dito sa gawas sa nasod, where the petition for adoption is filed, and then, however, the supervised trial custody is undertaken and the decree of adoption is issued outside of the Philippines. Dito sa gawas sa nasod ang procedure when it comes to adopting a Filipino child. Ato sa foreign country, and then a petition, Ang supervised child custody as well as the decree is issued outside of the Philippines. Now, kinsa man ang pwedeng i-adopt under the domestic adoption. A child legally available for adoption must be below 18 years of age and judicially declared available for adoption. Kailangan ma-declare gid siya as available for a child available for adoption, legal adoption. May gitawag og CDCLA, certificate declaring the child legally available for adoption. That's it. And then the intercountry adoption, only legally free child may be adopted. Unya, ang requisites ana, lahi siya, dapat below 15 years of age and has been voluntarily or involuntarily committed to the DSWD in accordance with PD 603. Ang exception lang ani sa domestic adoption on the requirement of the age below 18 years old is kung imong legitimate son or daughter ang bata, or illegitimate son or daughter by a qualified adopter. Kung illegitimate ang bata niya, he wants to adopt in order to confer a legitimate status over the child, pwede. And then person of legal age if prior to the adoption said person has been consistently considered and treated by the adopters as his or her own child since minority. Kana bitong anak-anakan ninyo, and then wag gyud siya na legally adopt. Pwede na siya even if he or she reaches the age of majority, pwede gihapon na siyang ma-adopt because that's one of the exceptions under domestic adoption. Kisa may pwedeng mo adopt under the domestic adoption? Filipino citizens. Kung Filipino siya, kailangan siya of legal age in full capacity, civil as well as legal rights, of good moral character, and has not been convicted of any crime involving moral turpitude, emotionally and psychologically capable of caring for the children, in position to support the care for his or her children in keeping with the means of the family. Unya, at least 16 years older than the adoptee. But this requirement may be waived if ang adopter is the biological parent of the adoptee or if the adopter is the spouse of the adoptee's parent. And kailangan siya nga permanent resident of the Philippines. Now, pwede bang mo adopt under domestic adoption ng aliens? The answer is yes. Same qualification provided nga appeal niyang mga additional requirements. Kailangan niyang country has diplomatic relations with the Republic of the Philippines. Kailangan niyang government allows the adoptee to enter his or her country as his or her adopted son or daughter. He should be living in the Philippines for at least 3 continuous years prior to the filing of the application for adoption. Basically, na siya din nagpuyo for 3 years continuously. And he must be or she must be certified by his or her diplomatic or consular office or any appropriate government agency that she has or he has the legal capacity to adopt in his or her country. Kaning nga requirement may be waived if siya is a former Filipino citizen who seeks to adopt a relative within the 4th civil degree of consanguinity or affinity, or one who seeks to adopt a legitimate child or daughter of his or her Filipino spouse, or one who is married to a Filipino citizen and seeks to adopt a relative within the 4th degree of consanguinity or affinity of the Filipino spouse. I think I failed to discuss how to count kanibitang atuang degree of consanguinity or affinity. Nakabaw na ba mo sa ang pagkwenta kung kinsa sa imong mga relative ang within the 4th civil degree of consanguinity or affinity? Anyone?
Yes, attorney.
Oh, sige.
Yes, attorney.
Come on, Mergelin.
From you, attorney, you will count up to your father or mother. Then from your mother or father up to your grandfather is your 2nd degree of consanguinity. Then from your grandfather back to your uncle or auntie, that's your 3rd degree of consanguinity. Then their offspring is your 4th degree of consanguinity. Am I right, attorney?
Yes, basically your first cousin is your relative within the 4th civil degree of consanguinity, and under the you recall under the family code you cannot marry your first cousin because that is still prohibited kay within the 4th civil degree pa man siya of consanguinity, diba? Ka remember mo aron? Basically mo na ha, mo first cousin mo na imong ika 4th civil degree of consanguinity. In counting the degree, you have to consider common ascendants. common ascendants. Kung panalitan kita Mergelin igagaw ta, naigagaw ta Mergelin because atong ginikanan managsuon, ang atong pagkwintaan na we have to consider our common ascendant. Kinsa may common atong ascendant? Atong common ascendant atong grandparents, correct? Kay nahimong igsuon atong maginikanan because of our grandparents. So, before mo down nimo ang pag-count, kailangan mo agi sa common ascendant. So, from me up to my mother, ngadto sa akong lola. So, from me to my mother, that's 1 degree. Dayon, mother to lola, that's 2 degree. Lola to your mama, that's 3 degree. And then your mama to you, that's 4 degree. So, muna nga, ikaw, Marjeline, as my first cousin in our layman's term, is my relative within the 4th degree of consanguinity. Kaning affinity is, ang inyong relationship is by reason or by operation of law. Kanang in-laws ba? Muna sila. So, basically, nakasabot na sa concept aning degree of consanguinity, no? Ang uban diha, kakuha ra? Guys, kira mo na, guys?
Yes, attorney.
Okay.
Yes.
Thank you.
Yes, attorney.
Yes, attorney.
Yes, attorney.
Okay. So, kisa may pwedeng mo adopt under intercountry adoption. Permanent resident of a foreign country, kung Filipino siya nga citizen, dapat permanent resident siya of the foreign country na siya capacity to act and assume all the rights and responsibilities of parental authority under Philippine laws, has undergone appropriate counseling from an accredited counselor in the country of domicile, has not been convicted of a crime involving moral turpitude, eligible to adopt under Philippine laws, in a position to provide the proper care and support and to give the necessary, basically pare-parehara og requirements, but agrees to uphold the basic rights of the child as embodied under Philippine laws, the UN Convention on the Rights of the Child, and to abide with the rules and regulations issued to implement the provisions of the ICAA, and then residing in the country with whom the Philippines has diplomatic relations, same yapon, possess all qualifications and none of the disqualifications, and at least 27 years at the time of the application. Mo ni siya ang variance from domestic adoption. At least 27 years of age at the time of the application and at least 16 years older than the child to be adopted at the time of the application. Unless ang adopted is the parent, unless adopted is the parent by nature of the child to be the adopter ni guys. The adopter is the parent by nature of the child to be adopted, or the adopter is the spouse of the parent by nature of the child to be adopted. Right? Play words. Now, who may adopt under intercountry adoption kung alien sila? Same, at least 27 years of age, 16 years older, unless of course katong na ay exception, has the capacity to assume all the rights and responsibilities, undergone appropriate counseling, etc., etc. Basically same requirements. Now, in domestic adoption, the general rule is the husband and the wife should jointly adopt. Otherwise, ang adoption shall not be allowed. Except lang kung ang isa ra ka spouse seeks to adopt the legitimate son or daughter of the other. Naminyo na siya before. Naminyo siya kaduha. Nato'y legitimate child ang iyahang asawa. Gusto sa niya nga mahimo niyang legitimate child, so pwede niyang i-adopt. That's the exception. Nga pwedeng siya ra ang mo adopt naturally. Or if one spouse seeks to adopt his or her illegitimate son or child, but the other spouse must give his or her consent. Kailangan na agyapoy consent. Or if the spouses are generally separated from each other. In intercountry adoption, ang rule is if the adopter is married, his or her spouse must jointly file for the adoption. Now, where do we file the application? Kung domestic, basically in the family court, it should be in the regional trial court of the province or city where the prospective parents reside. And after the filing, the petition shall not be set for hearing without a case study report by a licensed social worker. Refer na siya guys sa social worker, and the social worker will be asked to render a case study report kung sa situation sa bata, unsa kay mamahimong consequence if ang bata i-adopt or i-grant sa court ang adoption or petition for adoption of the child ngadto sa prospective adoptive parents. So basically, paabuton sa korte ang case study report nga buhaton sa isa ka licensed social worker. In intercountry adoption, man siya pwedeng i-file. It may be either in the family court having jurisdiction over the place where the child resides, or may be found, or pwede sa ICAB, kani Intercountry Adoption Board, through an intermediate agency, whether governmental or an authorized and accredited agency in the country of the prospective adoptive parents. If it is filed with the family court, the court determines sufficiency of the petition in respect to form and substance. And after which, ang kanang petition, i-transmit reyapo na to the ICAB, the Intercountry Adoption Board. If ang petition is already with ICAB, it conducts matching of the applicant with an adoptive parent. Ako, I'm actually a member of the CWSG, kining Child and Welfare Specialist Group of the DSWD. We do matching of children sa prospective adoptive parents. So, during the matching, among tanawon kung kaning bata mahaong ba ani nga prospective nga adoptive nga parent. So, tanaw na mo ang needs sa bata, tanaw sa na mo ang capability sa parents. So, basically, that's also what the ICAB is doing when it comes to intercountry adoption. They will conduct a matching of the applicant with an adoptive child. And after the matchmaking, the child is personally fetched by the applicant for the trial custody, which takes place outside of the Philippines. Once ma-match na, ipadala na ang bata dito for trial custody. So, ayan ba kung unsay relationship nila during this trial period or trial custody. Domestic adoption natin gitawag og supervised trial custody. This happens when there is a temporary parental authority vested to the prospective adopter. This will be a period of at least 6 months. So, wayan ba sa relationship between the adopter and the adoptee, the future adoptee? But it may be reduced by the court or upon motion. Kung tanaw sa korte, pwede na ni nga ang bata i-grant na ani nga parents, so it may be reduced to a lesser period. If the adopter is an alien, the law mandatorily requires the completion of the 6-month trial custody and may not be reduced. Except kung kana siya nga alien, former Filipino na siya, who seeks to adopt a relative within the 4th degree of consanguinity or affinity, or one who seeks to adopt the legitimate son or daughter of his or her Filipino spouse, or one who is married to a Filipino citizen and seeks to adopt jointly with his or her spouse a relative within the 4th degree of consanguinity. Basically, balik-balik rin ang mga exceptions, guys. So just take note of the procedure and the requirements before the grant of the decree of adoption. In supervised trial custody with respect to intercountry adoption, this process takes place outside of the country and under the supervision of the foreign adoption agency. This is also for a period of 6 months. Kung unsuccessful siya, ang ICAB shall look for another prospective applicant. Ang repatriation sa child is to be resorted only as a last resort. So, pabalikon na yun ang bata diri kung wa na gyud mapalgan nga adopter or prospective adopter ang ICAB. Once napay chance nga ma-match or napay lain nga pwedeng ma-match sa bata, paningkamutan gyud na sa ICAB nga ma-match ang bata. Now, if during the supervised trial custody, kung successful na siya, ang ICAB would transmit a written consent for the adoption to be executed by the DSWD, and the applicant then would file a petition for adoption in his or her country. So basically, i-grant, tagaan na siya o written authority by the DSWD, and that's the time wherein the applicant for the adoption may file the same to his or her country. Now, is there a written consent required from the children of the adopter? Yeah. Yes, written consent of the following to the adoption is required in the form of an affidavit if the adoptee or by the adoptee if 10 years of age or over. Kung ang adoptee kay 10 years na siya pataas, kailangan iyahang consent. Kailangan sad ang written consent from the biological parents of the child if known, or legal guardian, or the proper government instrumentality which is legal custody of the child. Also, legitimate and adopted sons or daughters 10 years of age or over of the adopter or adoptee. of the adopter and adoptee, if any, illegitimate sons or daughter 10 years of age or over of the adopter if living with the said adopter and the latter spouse, if any, and the spouse, if any, of the person adopting or to be adopted. Basically, mo ni siya ang mga consent needed. In intercountry adoption, ang written consent sa biological or adopted children above 10 years of age in the form of certain statement is required to be attached to the application to be filed with the ICAB or with the family court. If satisfactory pre-adoptive relationship is formed between the applicant and the child, the written consent to the adoption executed by the DSWD is required. Now, what are the instances when adoption may be rescinded? Pwede nimong ma-rescind or ma-cancel ang adoption. These are the following instances: repeated physical and verbal maltreatment by the adopters or by the adopter despite having undergone counseling, attempt on the life of the adoptee, sexual assault or violence, abandonment, and failure to comply with parental obligations. And the prescriptive period basically is kung incapacitated within 5 years after he reaches the age of majority, if incompetent at the time of the adoption within 5 years after the recovery from such incompetency. Basically, ang makafile ragyud aning rescission no, of the adoption is the adoptee, not the adopter. Okay? Is there a prescriptive period, just as mentioned earlier, 5 years upon or after he reached the age of majority or after recovering from incompetency? Karon, kung na-adopt na, unsa may na-rescind rather, what are the effects of the adoption rescission? Ang parental authority of the adoptee's biological parents, if known, or the legal custody of the DSWD shall be restored if the adoptee is still a minor incapacitated. Now, reciprocal rights and obligations of the adopter and the adoptee to each other shall be extinguished. Remembering when you become an adopted child of the adopter, ang imuhang status is like that of a legitimate child. Once there is a rescission of adoption, kana siya ang inyong relationship, reciprocal rights and obligations will be extinguished. Okay? There's also a cancellation of the amended certificate of birth of the adoptee and restoration of his or her original birth certificate. And succession rights shall revert to its status prior to the adoption, but only as to the date of judgment or judicial rescission. Vested rights acquired prior to judicial rescission shall be respected. Now, unsa may effects sa adoption, atong na-mention earlier nga nanay parental authority, except in cases where the biological parent is the spouse of the adopter, the parental authority of the biological parent shall terminate and the same shall be vested in the adopters. Okay? It's as if di na nimo ginikanan imong mga biological parents. Imong biological parents na are already the adopters. Also, you are given a legitimate status. The adoptee shall be considered the legitimate son or daughter of the adopter for all intents and purposes, and as such is entitled to all the rights and obligations provided by law to legitimate sons or daughters born to them without discrimination of any kind. Also, naa sila successional rights. Okay? Now, kanilang. In legal and intestate succession, the adopters and the adoptee shall have reciprocal rights of succession without distinction from legitimate filiation. However, guys, if the adoptee and his biological parents had left a will, the law on testamentary succession shall govern. The family code provides that the adoptee remains an intestate heir of her biological parents. This was actually an obituary dictum in the case of INRE in the matter of adoption of Stephanie Nati Astorga Garcia. This volume 454 of the SCRA, page 541. Ang nahitabuan niingon ang Supreme Court nga bisan pag na-adopt na si adoptee in this case, mahog nga usag gyapon sa iyang mga heredero ang iyang biological parents. So simultaneously si biological parents o si adopter adoptive parents niya are his or her intestate heirs. Okay, iyang intestate heirs. Pero kung na siya will nga gibilin, wala problema. Pero wala siya will mo na mo-govern ang intestate succession, meaning equal ang rights sa iyang biological parents and adoptive parents, okay? Kaning kaso sa Badua versus Court of Appeals, ang petitioner here, si Marisa, claims to be an heir of spouses Vicente and Isabella Benitez, being the legitimate child of the spouses. Ang kaning claim by Marisa was done after Victoria Benitez Lierio and Fyodor Benitez Aguilar, ang mga igsuon ni Vicente and pag-umangkon, filed a special proceeding for the settlement of estate and administration of the same. Nangamatay naman gud ni sila si Vicente o si Isabel. Karon, ang during sa trial, kani sila si Victoria niingon nga si Vicente kuno wala na sila biological child because they were incapable of procreating a child, as testified by the obstetrician gynecologist of Isabel. Now, the trial court, after considering the documentary evidence submitted by Marisa, decided in favor of Marisa. So, nabot ni sa Court of Appeals. Pero ang Court of Appeals, gi-reverse ang ruling sa trial court for failure kuno to establish her status and prove her biological and blood kinship with the aforesaid spouses. So, naabot ning kasuha sa Supreme Court. Ang question here is whether or not the decision of the appellate court is proper. Now, ningon na Supreme Court, yes, the decision of the Court of Appeals is proper. At this juncture, it might be me to mention that it has become a practice in recent times to people who want to avoid the expense and trouble of judicial adoption to simply register the child as their supposed child in the civil registry. Perhaps in this case kono, si Vicente Benitez, though a lawyer himself, thought that he could have avoided the trouble if not the expense of adopting the child Marisa through court proceeding by merely putting himself and his wife as the parents of the child or her birth certificate. Basically, gisimulate ra nila ba ang birth sa bata. Gisuwat ra diretso dito nga sila parents. Ningon na Supreme Court, but definitely the mere registration of the child in his or her birth certificate as the child of the supposed parents is not a valid adoption. It does not confer upon the child the status of an adopted child and the legal rights of such child, and even amounts of simulation of the child's birth or falsification of his or her birth certificate, which is a public document. Okay, so that's an illustrative example of simulation of birth in relation to the issue of adoption. I hope nakasabot ramos distinction between domestic and intercountry adoption, albeit very fast-track discussion. Anyway, ako ra mo tagaan sa akong notes para inyo rang ma-review. But let's now proceed to the continuation. Wait lang ha. Kamay na lang ni guys. Support. Support, this comprises everything indispensable for sustenance, dwelling, clothing, medical attendance, education, and transportation, in keeping with the financial capacity of the family. The education of the person entitled to be supported referred to in the preceding paragraph shall include his schooling or training for some profession, trade, or vocation, even beyond the age of majority. Ang transportation shall also include expenses in going to and from school or to and from place of work. Dayon, under Article 195, this basically enumerates the persons who are obliged to support each other to the whole extent. Okay? So, basahan lang ninyo guys, kisa na yung mga tawhana ang obliged to give you support. Okay? Ang spouses, of course, legitimate ascendants, descendants, etc., etc. Basahan lang ninyo palihog. Dayon, ang remember lang nga ang amount sa support is basically or shall actually be in proportion to the resources or means of the giver and to the necessities of the recipient. You cannot demand mga extreme kaayo nga amount if dili pod kaya sa giver, okay? Unya dili pod kailangan sa recipient. Basically, in proportion na siya sa resources or means of the giver and to the necessities of the recipient. Mao nang ang korte mo ingon gina ang support di gyud na siya fix. It depends on the needs of the recipient as well as of the means and resources of the giver. Now, Article 202, 203, these are amplification of articles of Article 201. So, basahan lang ninyo guys, ha? Palihog lang. Then, Parental Authority. Parental authority pursuant to the natural right and duty of parents over the person and property of their unemancipated children. Parental authority and responsibility shall include the caring for and rearing them for civic consciousness and efficiency and development of their moral, mental, and physical character and well-being. Now, the general rule, ladies and gentlemen, is that the father and the mother shall jointly exercise parental authority over the persons of their common child. Unya, kung naaman galing disagreement, no, ang doon ingon nga ang father's decision shall prevail unless na judicial order to the contrary. Unya, kitang mga anak shall always observe respect and reverence towards our parents and are obliged to obey them as long as the children are under the parental authority. Okay. Kani, Article 213, usa ni siya sa mga important kay nga provisions of the family code pertaining to support. In case of separation of parents, parental authority shall be exercised by the parent designated by the court. The court shall take into account all relevant considerations, especially the choice of the child over 7 years of age, unless the parent chosen is unfit. Okay? And remembering, a general rule is no child under 7 years old shall be separated from the mother unless the court finds compelling reasons to order otherwise. Yeah. In case of death, absence, or unsuitability of the parents, substitute parental authority shall be exercised by the surviving grandparent. Okay? Muna siyang rule. In case several survive, ang gidesignate sa court maoy makakuha sa custody. But of course, the court should take into account the considerations with respect to the giving of the best interest of the child. Okay? So, tan-awon na sa korte kung kinsa man nga grandparent ang mas makahatag og maayong kinabuhi sa bata. Also, remember in 215 that no descendant shall be compelled in a criminal case to testify against his parents and grandparents, except when such testimony is indispensable in a crime against the descendant or by one against another, or again by one parent against the other. Muna gitawag og filial privilege. You cannot be compelled to be a witness against your parents or grandparents, except kung ikaw ang nikiha sa imong parents or grandparents, or except when ang isa ka parent nimo ang kontra niya, usa sa nimo ka ginikanan. So basically mo na siya ang rule. Now, with respect to substitute and special parental authority, kung wala na kay parents, or wala kay guardian nga gi-appoint sa court, ang maka-exercise og substitute parental authority over sa child kay kani. Pero in order sa surviving grandparent, unya kung why surviving grandparent, ang imong oldest brother or sister nga over 21 years of age, unless imong brother or sister is unfit or disqualified, and the child's actual custodian mo nang last kung wala gyud ning duha first two over 21 years of age unless unfit or disqualified. Then whenever the appointment of a judicial guardian over the property of the child becomes necessary, the same order shall also be given preference, also be observed. Okay. Dayon kaning foundlings, basahan ninyo guys. Kani, naani siya yung mga cases. Article 218, the school, its administrators and teachers, or the individual entity or institution engaged in child care ni, shall have special, this is child care, wait. Child care shall have special parental authority and responsibility over the minor child while under their supervision, instruction, or custody. Authority and responsibility shall apply to all authorized activities, whether inside or outside the premises of the school, entity, or institution. Kani ko no guys, example, si Glenda is a teacher in the University of the Visayas teaching, let's say, elementary students. Unya, during the flag ceremony, na siya'y mga estudyante nga si, let's say, Alvin o si Carlo, nagsumbagay. Unya, karon in the course of the sinumbagay, sus kay napangag man si Carlo, okay? So, nagkagasto for the medical expenses, for the postiso baron ni Carlo, mutubok mo na, elementary pa. So, let's say, medical expenses, samaran baron si Carlo and all that. Question, can the school be held liable for the injury sustained by Carlo in this case, even if it was inflicted by the student? Isa to nga student ang nanumbag ni Carlo, si Alvin? Alvin, yes.
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 Attorney.
Yes, attorney.
Attorney.
Yes, the school having the substitute parental authority will be obliged to pay for the damages incurred by the estudyante Carlo in this instance. Kay ang bata is with the custody man of the school. If nasa classroom, mahimong liable basically ang teacher if outside the classroom, but within the school premises, basically ang eskwelahan, ang administrators. But even if it is committed outside of school, but it is a school sanctioned, it's an activity sanctioned by the school, liable gina ang eskwelahan. Anyway, Article 129, those given the authority and responsibility under the preceding article shall be principally and solidarily liable for damages caused by the acts and omissions of the unemancipated minors. Ang parents dere, ang judicial guardians or person exercising substitute parental authority over the said minor shall be subsidiarily liable. Ang primary gyud nga liable is the school, okay? Ang eskwelahan, ang administrators sa eskwelahan and all that. But in case of insolvency of the school, the administrators, ang secondarily liable would be the parents of the child. So kung si Carlo mo'y nakasa, ang iyang parents will be subsidiarily liable in case ang school, ang administrators dili makabayad sa expenses nga tukang or sa damage nga tukang Alvin. The respective liabilities of those referred to in the preceding paragraph shall not apply if it is proved that they exercise the proper diligence required under the particular circumstances. This is a defense. Kung makaingon sila nga they exercise extraordinary diligence to prevent the children from, punching each other, kana pwedeng makaingon ang school dili ko liable. Only the parents of Alvin will be liable. But otherwise, ang general rule is that ang school will be held primarily liable. Subsidiary ra ang parents. Okay? So I think that ends the discussion on parental authority. Kanilang ato lang ning padaganan ang last na lang gini nga topic in persons and family relations, provisions on RA 9048 with respect to the correction of clerical or typographical error in an entry or change of first name or nickname in the civil register without the need of a judicial order. Okay? This is RA 9048. Unsa man ni siya nga balaod na. This actually provides for the authority to correct clerical lang guys. Di man clerical or typographical error and change of first name or nickname. Okay? Typo or clerical error pwede sad first name or nickname. So, unsa man sila? Unsa may matawag ni mga first name? Kaning given to a person which consists of one or more names in addition to middle and last names, name that appears in the civil registrar, First name of the child appearing in the birth certificate. And yeah, there's change of name. The old name is not erased or corrected. The new name is simply annotated in the registry of or in the civil registry. Bisan pa og i-change na imong pangan, guys, dili gyud na ingon nga erason imong pangan sa imong birth certificate. Ang buhaton ra na sa civil registrar is just to annotate, okay, the change or the correction. So let's say mao ni imong birth certificate kani, dili na siya papason diri imong name, nga imo nang i-correction imong first name, or there is a certain spelling nga nasayop, okay, panitan kani. Ang imong middle name is corrected from Salcedo to that of San Lorenzo. And mother's middle name is corrected from Solido to that of Soliba. Ang buhaton ra na sa civil registrar is just to annotate kaning kilid kita man kini diha na isuwat sa civil registrar, diha ra na niya i-annotate ang change. Unya dayon, after anang ma-annotate na, pwede na rin imong gamiton ang corrected na version sa imong pangalan. Okay? Unsa man ning gitawag natog clerical error? This is a mistake committed in performing clerical work in writing, copying, transcribing, or typing an entry. This is harmless and innocuous, visible to the eyes, or obvious to the understanding, and can be corrected or changed only by reference to other existing record or records. Unsa may mga dili clerical under this law? Kanang nag-involve og nationality, kanang age, status, or sex. Kung kana gani, kailangan na gyud na siya og change, correction na gyud na siya of entry, okay? Or change of name baron, or correction of petition for correction of entry. Kaning nationality, imbes Filipino, ang nadito Chinese, di na pwede nga maingon ka typo ra man na. Tanawa kung naangod ako kung mata niya, nganong Chinese man na diha, dili pwede. Kailangan mo petition jud ka sa court. You have to prove that indeed you are a Filipino. With respect to your age, you cannot just say I'm just 18 years old. Kanang nataw ko in this particular year, di na pwede. Kailangan imo pa nang ipa-correction yun na gyud na judicial order. Also with respect to your status, whether you are legitimate, illegitimate, or legitimated, kailangan yun na siya og court order. But with respect to legitimated, mo file ra ka ana di ay sa civil registrar o affidavit of legitimation ng imong parents. Dili na kailangan og judicial order. But other than that, ang lain pang status when you claim for like legitimate status, you have to seek for a judicial order to that effect. Dayon ang sex nimo, if you are a male or a female, kailangan ka mo seek og judicial recourse. Dili pwede nga si civil registrar lang ang mo korek-korek ana. Kani babae na ni tan-awon, ato ni di man ni siya lucky oy. Ato ilisa ni iyang male diri into that of a female. You cannot do that. Kailangan ka mo agi sa korte, okay? Unsa may mga examples di aning clerical errors? Kanang mga misspelling, mga na-interchange ang mga letter, imbis Juanito na himong Jaunito, di ba? Klaro na kay nga clerical. Mga unnecessary letter nga na-insert like Florante, na himong Floriante. These are examples of clerical errors. What else? Mga words are not in the right place or space. Mga first, middle, and last names are interchanged. Na himong Ramon Cruz Domingo, ang Ramon Cruz Domingo na himong Ramon Domingo Cruz. Okay? So basically kani siya pwede nimong ma-correct. Unsa may grounds for the change of first name? Because we mentioned earlier nga under this Republic Act, pwedeng clerical errors, pwede ang change of first name, di ba? Kung imong first name is ridiculous, tainted with dishonor, or extremely difficult to write or pronounce, or the new first name has been habitually and continuously used by the petitioner, and he has been publicly known by that first name in the community, or the first name will avoid confusion. The change of first name will avoid confusion. Example, ana, ang use sa Maria and MA lang ang Maria in a compound first name. So, imuhang Maria nga full Maria, imong ipa-change into Maria just an MA. Also, abbreviated first name, kanang Maria Lourdes Sanchez Bautista to that of Marilu Sanchez Bautista. Pwede rin na kuno siya under the LCR or under this rule. Kisa may pwedeng mo file a person of legal age at least 18 years old and above who has direct and personal interest in the correction of the error or change of the first name. Una ani ang honor sa record, or ang spouse sa honor or children sa honor, parents, brothers, sisters, grandparents, guardian, person authorized by the honor or by the law. Form to be used and content of the petition. The petition should be in the form of an affidavit subscribed and sworn to before a person authorized to administer oath. It shall contain the merits of the petition, also may basis niya, ang competency niya, ang erroneous entry to be corrected, and the proposed correction. The first name to be changed or the proposed new first name. Okay? Ang mga supporting nga mga documents, mao ni siya guys, certified machine copy of the certificate containing the alleged erroneous entry, not less than 2 public or private documents upon which the correction shall be based. Kani siya guys, ay mga baptismal certificate, mga JUDICIAL records, picture lang yan ninyo or screenshot, okay, in order for you to have an idea or maka-advise mo sa inyong mga friends dira kung mga tana. Supporting papers for correction of clerical error. Kailangan there has to be notice and certificate of posting, machine copy of the official receipt of the filing fee, any other documents which the city or the municipal civil registrar may require or the petitioner may submit to ensure approval of the petition. Also, documents required for the correction of the clerical error, clearance from the authorities, kanang gikan sa mong employer baron, kung employed ka, from the NBI, police clearances, and other clearances required by the civil registrar. Also, the proof of publication. Kani nga affidavit kailangan ni siyang i-publish, okay? There has to be a copy of the newspaper clipping nga i-attach nimo sa imong petition. Posting and publication. Petition for correction of clerical error to be posted for 10 consecutive days. The petition for the change of first name must be posted for 10 consecutive days, and the publication in a newspaper of general circulation must be done once a week for 2 consecutive weeks. Alright? So, kailangan na ipapublish na nimo ha. Aha man na nimo i-file sa local civil registrar, sa Philippine Consulate, and sa Sharia Court. Kung pananglitan, nibalhin ka, petitioner who is now residing in the place other than where his record is registered. Basically, kani kung ahanin mo i-file, where to file, you have to file this with the LCR kung asa na file ang imong birth certificate. Okay? Adto na nimo i-file. Or kung nakagawa sa nasod, sa Philippine Consulate, or before a Sharia court. Kung panalitan, nibalhin na kag lugar, layo kaayo ka sa imuhang natawhan o sa imuhang present ni nga gipuy-an, aha man na nimo i-file. Kaning example, si Mr. X was born in Cotabato City. She migrated to Esperanza, Sultan, Kudarat. She wants to correct a clerical error in her birth certificate. She may submit her petition to the Municipal Civil Registrar of Esperanza, Sultan, Kudarat. Unya, si MCR na sa Esperanza ang mo-make sa preliminary processing. Unya, i-forward na niya ang petition dito sa LCR office sa Cotabato City kung asa ka na tao. So that's basically the procedure. Now, ang decision of the civil registrar shall be rendered within 5 working days after the lapse of the posting or the publication period. The decision approving the petition shall be submitted to the office of the civil registrar within 5 working days after the date of the decision for review. When the decision is denied by the city or municipal civil registrar, the petitioner has 2 options. Pwede siyang mo appeal to the office of the civil registrar or to file an appropriate petition with the regular court. Di man nga when you avail of this privilege, you can only do so only once. Okay? The decision approving the change of first name in the birth certificate may be used to correct the name of the same petitioner in other affected records. Now, mga fee, kanito necessary, tanawa lang ninyo, basically, mauni siya ang charges. when the slides were made. I don't know kung pila na karon. Consider this: errors in other parts of the certificate of live birth other than those previously discussed can be considered clerical or typographical error depending heavily on the justification of the petitioner and papers supporting the petition. Pwede ka ng religion, type of birth, number of children, mga birth order, occupation, all that. Pwede na siya. But katong you-mentioned earlier, nga mga instances wherein clerical correction over the entries in the certificate of live birth cannot be done. You have to take note of those. Katong nationality, the sex, the status, and the age. Also, no error of any kind shall be corrected at the back page of the certificate of live birth because technically all the entries there are part of the legal instruments, so no correction is allowed. And we're done. Wow, 9:05. You have questions so far? Yes, Aiza, you have question, Aiza?
Yes, attorney. I have here a question, attorney, regarding the clerical error. I was able to change and adopt a new name, attorney, without undergoing the process of petition for clerical error. But my father filed for another registration of a new name to the local civil registrar. My question, attorney, is, was it lawful or void, attorney?
Unsa to day?
The previous I was able to change my whole name as attorney and adopt my given name now without undergoing the process of petition for the clerical error. But my father, what my father did is filed another registration to the local civil registrar.
Oh, okay.
Yes, attorney. So was it lawful or void or?
I like Saba, day. I like Saba. Okay. Okay.
And then, attorney.
Yeah, but under the law, you cannot really do that. But you know, at some point, makita kaagi. So I like Saba. Kira na.
And then, naapod ko Andres, attorney na last na note. I don't know, I'm not sure if this question has been raised or answered kay the last ko earlier. So, this is regarding the case what will happen, attorney, if the wife of an alien or a foreigner died and he is the wife of the foreigner had no other kin and he is the only person who can inherit all of the properties. As discussed earlier, nabtan pa nako to na discuss nga ang mga foreigner or alien dili sila pwede ka inherit og land. So is it an exception for the foreigner if he is the only rightful inherit the land properties?
Yes. We answered that earlier, Aiza. This was also asked by your mate. I forgot. But yeah, kung wala na gyud siya laing relative ang katong asawa, the one who can actually inherit by virtue of intestate succession. Intestate succession meaning walay will ha, wala na dapat gihatag siyang asawa, wala na gibilin siyang asawa, wala gi will nga siyang asawa. Walay laing makamana anak kundi ang foreigner. This is the only instance wherein the foreigner can actually obtain a land here in the country by virtue lang of intestate succession. Or kung kaning foreigner formerly a Filipino na siya, but there is a certain ceiling pod kung pila ra pod ka square meters ang pwede niya nga ma-purchase. But other than that, kung katora siya, foreigner siya, bana siya habilin sa Pinay, wala laing relative ang Pinay, maka-inherit siya by virtue of intestate succession. This is an example. Okay?
Attorney, thank you, attorney.
Question, attorney.
Atong tag-iya sa motor, ang plate number kay 9545 PE kay pwede na daw.
Okay, Carlo. Yes, go ahead.
Okay. Anong sa case akong mother, attorney, iyang name is Karen and the spelling sa iyang school records and sa records niya sa DepEd kay she's a teacher man is Karen. Pero katong ni-try siya og kuha sa iyang passport, we found out nga naka-record sa iyang certificate of live birth is Karen. So, clerical error na siya or change of first name na dyan?
Typo na mo. Yeah.
Attorney.
Typo na.
Okay. Thank you,
Clerical
attorney.
error na siya, Carlo. Try to file a petition with your local civil registrar.
Okay. Thank you, attorney.
Yes.
Attorney, can I
Attorney.
have one question, attorney?
Yeah. Oh, ha, guys. Kinay na, guys. Sige, guys. Okay.
Kuan lang, attorney. Kuan lang, simple lang kayong pangutanan ako, attorney. Makapugos ba og pangayog suporta imong partner kung wala kay trabaho?
Naturally, dili. Because kung wala kay ikahatag po, so may muyahatag. Kung wala kay ikahatag. As
Okay.
earlier, diba?
Salamat.
Yeah, it depends on the resources and the means of the giver.
Thank you, attorney.
Kung wala kay ikahatag, digid ka mapugos. Yes.
Attorney Abelianeda, attorney.
Oh, yes.
It's a sort of inquiry lang siya, attorney. The girlfriend of my brother had imprisoned for 6 months in city jail, mas mga attorney, sa nadapita diha sa may unahan ng lahog. And then wala kabalo ako ang brother nga buntis dito siya. So karon ni balik pagkagawas ni attorney ka 6 months raman to iyahang pagka-priso. Pagbalik ni attorney nagdala siyang bata dito sa amua, January na siya. And then gibiyaan niya ang bata dito sa amua, attorney, nga wala gid siya, walay papilis ang bata niya, na wala na gyud ang babae. Karon ang bata is mo 3 years na siya. Pwede na mo siya ma-adapt ang bata. Or amo siyang surrender sa DSWD.
Pwede siya. Ang asama ang papa. Imo ang igsuon, no? Ang sa to?
Ang akong brother sa attorney kay dili siya mo angkon tungod kay kami sa family na mo is we are all white complexion, and din ang bata mo siya violet, nga mo siya negro.
Paluoy.
Pero nangasa kong mama, kami jud mo ay nag-atiman gid sa bata, naggatas hangtod nga ang bata karon 3 years old na, and then we're planning
Pwede re-adopt.
Pwede naman siya adapt, attorney, no? Pero akong mama nga 73 years old is not qualified for adoption.
Dili na siya ikuan, dili na siya i-grant, ma'am. Dili na siya i-grant.
Sige, thank you, attorney.
Any other
attorney, I have a question.
Yes.
One last question. Attorney, I have a question. My real birthplace is in Leyte, but the registered birthplace in my birth certificate is Antipolo Rizal. But before, my real name is Angelique, but it was only on the baptismal certificate. But pagkagawas sa birth certificate na ko, attorney, ang akong name ni gawas is Mergeline na. Lawful ba to siya, attorney?
Yeah, we have to follow what's stated in your birth certificate. Mao naman kanay mo nagamit sad in your other records.
Yes, attorney.
Okay ra.
Sa baptismal ra to siya, but nakasecure po sila baptismal na ko nga Mergeline na ang akong name.
You just follow the
naman siguro to mo conflict, attorney.
Dali ra.
Sige. Thank you, attorney.
Yes.
Attorney, one clarification.
Okay, what's that? Sir Bon.
Attorney, kanang kuan ba? Dili nila clerical error noon or not biological. Kana bitong transgender? Ka-change mo na sila o gender?
No. That's Republic versus Silverio. Yeah, no, you can't do that.
Okay, good. Thank you, attorney.
Okay. Thank you, everyone. It's been... Napay question? Wala na?
Ako, attorney.
Naapa? Alvin?
Yes, attorney.
Yes,
Regarding sa presentation ng attorney, can we have a copy of this?
Yes. I'll give you a copy of this. Ako lang sana i-convert into PDF ha, then akong ihatag sa inyo ha, para narong mo yung browse. Katulang cases sa katong recorded na ko nga video bitaw katong cases, kaya wala lang to na-include dire sa mga recorded videos, but I think you were able to take note of those man, no? So okay ra siguro. Kanilang gyud siya nga presentation, and katong previous nako nga discussion kay some ani kay mga provision raman akong gikuan good akong mga cases kay namo ko notes, so nara dito sa akong notes. Pero tagaanta mo ani nga presentation, Alvin, don't worry.
Salamat po, attorney.
Okay. Any
Thank you, attorney.
Other question? Okay. Thank you. So thank you.
Thank you, attorney.
Thank you kaayo everyone for being so patient this semester. This has been very challenging for both the professors and the students, pero nakita namo gyud nga ang students are also trying their best to keep up with the changes sa situation because aning pandemic, and we're very thankful that you stayed with Julius Law School despite all these challenges. And I hope that I'll be able to see you in the next semesters. No, let's say in your second year, I'll be handling credit transactions. So maybe magkita ta in your second year if you ever pass my subject, persons and family relations, which I'm sure you will because I'm sure nagtuon man mo. And I hope you stay inspired and stay determined no to focus your law studies, and dili lang kay nagtuon mo kay wa mo lingaw because of the pandemic. I hope you are really here in law school because you want to become lawyers. Moro yun na amo ang gipangandoy nga among mga estudyante mamahimo jong abogado sa umaabot og sa tukma nga panahon. So, having said that, I'd like to thank everyone sa inyuhang patience and inyuhang pagstay sa Julius Law School and for staying in my class. Okay?